And this course, there's a lot of forms with contract paperwork, so it stands to reason that this class deals with some paperwork. I don't want to do it in one chunk because I think that's hard to look at all the forms all at once. So we're going to kind of break these up into bits and pieces. And let's see, yes. To kind of piggyback off of where we left last night. There you go, Missy. To kind of piggyback where we left off last night, we were in the throes of chapter 14, and we were talking specifically, we ended talking about that buyer's due diligence period and all of the things that they should consider doing during that due diligence period. Obviously, different scenarios, different situations, different transactions, different. But again, just kind of gives us a general idea of where to start and where to go. Kimberly, it looks like I need your license number too. I thought I saw that earlier. Maybe it disappeared. I don't know, but thank you. So kind of to piggyback, before we moved on to the next section of 14, I want to look at a couple forms that, we mentioned, but I didn't specifically address. So let's look first at our due diligence request and agreement. The buyer's agent is going to use this to present to the listing agent on behalf of their buyer to their seller when the buyer wants to ask for repairs. Now, obviously, you can send an email and say, will you do repairs? But this form makes it look official. It's more formal. If the seller agrees to do the listed repairs and they're going to sign, this may be the jump off for negotiations for round 2 of negotiations. So maybe the seller looks at this list and they say, no, I don't want to do all of it. I'll do some of it. Anything's negotiable, guys. So at least starting with presenting this form to the seller for them to consider. Our forms, most of our forms come from the North Carolina Association of Realtors, so our NCAR forms. If you're a realtor, you have access to, or your firm has access to these forms. And a lot of, or many of these forms come with guidelines to complete. So if you're not sure how to properly complete a form, or if you don't know what goes in this blank, if it comes with the guidelines, and that's going to help you know what to plug in. All guidelines, all forms, everything can be found at the North Carolina Association of Realtors websites. So once you become that realtor, you have access to that website. They want your NRDS number, NRDS. It's a number that's like this long. You get when you join NAR, and you can access anything that the North Carolina Association of Realtors produces, including these guidelines to complete. So if we make this a little bit bigger so we can see it, there we go. So this is that we're going to identify the buyer and the seller and the property. And then this says, based on the buyer's due diligence, the buyer requests and the seller agrees to the following. And then we're going to list the things specifically that the buyer would like the seller to repair. Be specific, you guys, because if you ask the seller to fix the electrical, they could go change a light bulb and say, I fixed the electrical. What is it about the electrical that you want the seller to fix? It might be handy to include that portion of the home inspection. So you may literally say the items 2 from the home inspection, and here's that portion of the report, right? So the seller can actually see from the home inspector what the issue is. I think if you just call the seller and say, will you fix the electrical? That's a really good way for them to say no. I also think it's a really good way to get the seller to say no if you're presenting this due diligence request like on the day that due diligence is up or the day before. Please don't send this at 4:30 on due diligence. What do you think the seller's going to say? No, I don't have time to do anything. So remember, we're doing our inspections and investigations as early as we can to give the buyer a chance to decide what repairs they want to deal with, if any, and also to give the seller the opportunity to decide if they want to do repairs. Maybe the seller wants to talk to their own electrician. Maybe the seller wants to have their own person come out. So just give them time to consider it. Always remember, you guys, though, that the seller's under no obligation to fix anything. So if they say no, prepare your buyers for that. The seller has every right to say no. but it never hurts to ask, does it? What do you guys think, for example, if you see something listed as is, what do you tend to think with as is?
Buyer beware.
Buyer beware. Yeah, I would agree with that.
They're not fixing anything.
They're not fixing anything. Even if it says as is, if you're the buyer's agent, your fiduciary is to the buyer. And if your buyer says, I want to ask for repairs, send in the repairs. They're probably going to say no, but what's it hurt to ask, especially when you're representing the buyer, right? We always got to do what's in the best interest of our client. I agree. When I see as is, I tend to think the seller's not going to do anything. I don't know. Things change, right? Maybe they will, maybe they won't. The worst they can say is no. The seller can't terminate because the buyer asked for repairs. So the worst they can say is no. So again, we're going to be specific. Like I said, if you can include that portion of the home inspection report so they can see what it is. If for some reason you need more, you need more room, then you can always attach an additional piece of paper to ask for those for those repairs. We got a couple blue notes here.
Hey, Julie,
Yeah.
I got a quick question.
Yeah.
Is that like, as it's sale, does that have any implications on home inspection? One of my friends just bought a house and they were selling it as is, and they didn't want the buyer, my friend, to do a home inspection on the property.
That came a thing, Andrew, with the crazy sellers market we're coming out of. And some buyers, I mean, guys, there were situations where multiple offer situations where there were 40 some buyers making an offer on the same property. And when you're one of 40, somehow you got to stand out amongst the crowd, right? And some buyers were going into that saying, I will waive the home inspection. And so it might be, Andrew, that they ran into that and it worked for them, so they're going to try it again. The seller can always say, I don't want you to have the home inspection, but it really is not up to them. It's up to the buyer. If they want to have it inspected, unless they choose to waive it to get in. Honestly, I don't know that that was the wisest decision for buyers. Again, think about some of these price tags on these homes. I mean, I'm not throwing down a couple $100,000 and waiving a home inspection, but
Yeah.
that's just me. But there were desperate times last year and the year before. So yeah, you know, anything's negotiable, and the seller can always ask you to waive the home inspection, but the buyer has every right unless they agree otherwise.
Got it. Okay.
Because remember, that's part of that buyer's due diligence, is their opportunity to learn as much about this property as they possibly can to decide, now knowing what I know, do I want to move forward with or terminate this transaction? You know, some buyers were offering what they were calling like an appraisal gap. Like, I know I'm coming in over appraisal value. So anything over $50,000, for example, I'll cover that appraisal gap. When I say some buyers were getting desperate, I mean, it was kind of like that. You know, we were seeing 5-digit due diligence fees in some cases. Where did that money come from? Right. But, you know, just buyers were doing what they could to get in. Keep in mind, anything's negotiable. So if the seller doesn't want to do repairs, then we might be able to work something out, like closing costs in lieu of repairs, or maybe adjust the purchase price. So this first note is kind of addressing that. If we're going to change the purchase price or the amount that the seller agrees to pay, then we're going to use the agreement to amend the contract, which we'll look at in just a second. Let's see. The buyer retains the right to conduct due diligence during the period. Buyer's advised to consult with their lender about any changes. Buyer has to agree to release the home inspection. The home inspection report is property of the buyer. The seller has no rights to it. They can choose to share it with the seller, but we need to have a conversation with our buyers. Do you want to release a portion of it? Do you want to release all of it? The portion being just the repairs that you're asking the seller to fix. There's a couple different schools of thoughts on that. Some buyers say, well, I just, you know, if I don't buy this house, if I send them a whole report and I end up not buying this house, I just bought them a home inspection. Other buyers may say, I want them to see the whole report to see if this whole thing, all I'm asking you to do is this, this, and this. So remember, you guys, we're fact finders. We're going to help people weigh out their options. And when it comes to what, if any, of the home inspection report they agree to share with the seller, they just need to be aware of those choices, those options. And then we have place for buyer. Once we have agreement, then we have place buyer on the left, seller on the right. Once the seller and the buyer, but specifically the seller signs this, this is almost an amendment. Who remembers what we said an amendment does?
You're changing something.
You're changing something. If the seller agrees to do a repair, we are changing one very important sentence in our offer to purchase and contract. And that one important sentence says, this property is being sold in its current condition. And as soon as the seller agrees to do anything, even just change a light bulb, this property is no longer being sold in its current condition. This property is being sold in the condition with a new light bulb or whatever that agreed upon repair is. So it's almost like we're amending, not the whole contract, but just that one teeny tiny sentence. And the seller now has the contractual obligation to complete any repairs that they may agree to. So due diligence request and agreement. Questions on this one?
So just to confirm, this specific form here would be considered an amendment, not an addendum.
Correct. Because we're doing this after we're under contract. We are, well
Gotcha.
within due diligence. Yep.
Gotcha.
Yep. Thank you, Nicole. The other one I want to look at to get us started is the agreement to amend the contract. A couple things on this one. First off, you guys see that amendment number and then the blank in parentheses. They just added this last July, not this past July, but July before, because you may have more than one amendment. You may have to make more than one change. So you would have amendment number 1, amendment number 2, amendment number 3. They did that for us to help us with our organization and to keep our stuff together. So this helps keep us, organized a little bit better. This form starts with a big red warning. The forms committees went into our forms, 8-10 years ago, and added these blue notes and red warnings throughout our forms. And they're here for a reason, you guys. They're here to help point out, help us see them. So this first red warning says all parties, including any lender and settlement agent, must be provided a copy of this agreement. Remember, we've already sent the lender and the attorney the contract when we first went under contract. And now here we are amending the contract. So it's reminding us that we need to get those changes to the lender and the attorney so they have that to work with. Again, we got the buyer and the seller and the property. And then you can see here the things that we're allowed to amend. Basically, it's what we fill in on the offer to purchase and contract. So if the parties renegotiate the purchase price, if they want to negotiate some additional earnest money, building deposit, maybe we need a longer due diligence period. You know what speaks when asking for more time? Offer them more money, offer them more due diligence fees. So if we need to change that, that's in there as well. If we're changing up that escrow agent, sometimes the good closing attorneys are like booked out for months in some cases. So we may need to change an agent or attorney just to get into our closing date or around our settlement date. So if we're going to change escrow agents, we may also need to change who's holding the earnest money. So we're going to acknowledge that here. Settlement date. How many day delay settlement did we say is built into our contract? You can show me. Okay. Yep. 7. We have a 7-day delay built into our contract. If we think that for some reason we may need more than 7, we can always renegotiate a settlement date. If we renegotiate a settlement date, we still have the 7-day delay. Unless you check this box. If you check this box, your new settlement date does not have a 7-day delay. Your new settlement date now has a 4-day delay. Don't check the box, they're going to stick with 7. Do check the box, and now you're going to have 4. So if you know, let's say it's new construction, that's the most common reason for delays. And let's say we've had lots of rain and they haven't been able to build and they know we're going to be 3 weeks out, then we can put in the new settlement date, the new projected settlement date, and whether you don't want that 7 or 4 delay built into it. If we're going to renegotiate those seller paid expenses, again, this and the purchase price could all be in lieu of repairs if that's how the parties agree to make that work. If we're going to add or remove the home warranty, and again, buyer signs on the left, seller signs on the right. Questions on this one? Comments on this one? Anything at all about what we covered last night up until this point before we continue on? Let's talk TRID. So continuing on in chapter 14, we're in the next little section there, picking back up on page 475. We're going to talk about RESPA and TRID. So we're going to talk about what RESPA means, Real Estate Settlement Procedures Act. We're going to talk a little bit about TILA. We're going to mention it, Truth in Lending Act. When you combine the two, you have TRID, and of course, we will break that down further for you guys in just a second. Like I said, we're the industry of acronyms, and TRID is like the acronymist acronym we have. It's an acronym of acronyms. Say acronym again. So we're going to want to sure we break that down and understand what all that says. Before we get in this discussion, I got a little video about TRID that I want to show you guys. It's on the next slide, and it should start. Nope. Okay, hang on. Don't worry. I got a plan B. Oh, wait a minute. I forgot to get you guys. Hang on. Where are you guys at? There you are. Okay. So now let me grab you. If you guys will, when this starts, if you will give me the thumbs up that you can hear it.
So, what is TRID? Well, let's start at the beginning. Whoa, that's too far. Let's start in 1968. That's when Congress passed the Truth in Lending Act to help promote the informed use of credit. The Federal Reserve was charged with implementing the act, so it introduced Regulation Z, which required lenders to issue a good faith estimate, also called a GFE, and a Truth in Lending Statement, also called the TIL, to loan applicants. Fast forward. Wait, that's too far. In 1974, Congress passed the Real Estate Settlement Procedures Act, known as RESPA, to add transparency to the cost of settlement services. The Department of Housing and Urban Development, also called HUD, was charged with overseeing the new regulations, so it issued Regulation X, which required a HUD-1 settlement statement at the close of real estate transactions. Fast forward once more a few decades and you'll see the economic crash of 2008 and the subsequent housing collapse. Then, in 2010, Congress passed Dodd-Frank, which created the Consumer Financial Protection Bureau, also called the CFPB. This group was charged with integrating disclosures under TILA and RESPA. That brings us to October 2015, when a 1,888-page CFPB rule is effective that gets rid of the TILA, says so long to the GFE, bids farewell to the HUD-1, and introduces 2 new shiny disclosures called the loan estimate and the closing disclosure. Well, those 2 little forms mean a whole lot of change for the real estate industry, and it's not just affecting lenders. Home builders, real estate agents, escrow professionals, and title agents are all in the same boat. TILA-RESPA Integrated Disclosures, or TRID, requires a lot of time and resources dedicated to preparing for process and software changes. Here at First American, we're ready to make this transition as seamless as possible for our customers. We're engaging with lenders, retooling our technologies, reorganizing our processes, and training our people to ensure that they know how to keep customers and transactions on course. Make sure you're keeping up with the times. Call your First American representative to find out how we can help keep your business and transactions on track.
Okay, so that gives us just a little introduction. So let's talk about TRID. One thing we just heard in the video, TILA has been around for a long time. RESPA has been around for a long time. They are not new. What's new is TRID. So TRID is the acronym for TILA-RESPA Integrated Disclosure. TRID is the combination of TILA and RESPA. TILA stands for the Truth in Lending Act, and RESPA stands for the Real Estate Settlement Procedures Act. Now, they do two different things, but they seem similar. And to the consumer, the average consumer that doesn't know the ins and outs and the throes of the loan process, it may even seem like they're seeing duplicate forms in some cases. When we see TILA, I want you to see that lending, because what TILA tells the consumer is the cost to obtain the loan. When we see RESPA, I want you to see that word settlement. RESPA tells the consumer the cost to close. So they're both related to the process. And again, they had forms that looked awfully similar. And there was confusion. Guys, the video also mentioned the housing market crash. I know you guys weren't licensed during then, but you guys familiar, you remember it, end of 08, 09, 2010. Yeah, things were not good in real estate during that time. And there's a cajillion theories about what went wrong, what caused the housing market crash. And while we're not going to get into all those theories, I will say one of the more common theories was fraudulent lending practices. I don't want to give the impression that all lenders are bad, because that's certainly not the case. And even back then, not all lenders were bad. But there was enough fraudulent activity that it was one of the possible causes of the housing market crash. And that's kind of when everybody stepped up a little bit and said, okay, we got to do something to protect the consumer. So as the video said, in 2015, we got introduced to TRID. We're not going to spend much time on TILA in this class, so we're going to talk a little bit about RESPA and then kind of the combination of the two. So let's first talk about RESPA, kind of what it looks like. Again, we got it to protect consumers. It's all about protecting consumers. The Consumer Financial Protection Bureau, CFPB, was another direct result from the housing market crash. The CFPB is the one that's mainly responsible for giving us TRID. You can see it in the name, what it's doing, what it's about. It's about protecting the consumer when they're originating a loan. So anything that's going to be a federally related mortgage loan, under this definition falls our federally related loans, our FHA loans and our VA loans, anything that is issued by a mortgage lender, anything that can be sold on the secondary market. So this pretty much encompasses any of our mortgage loans for residential properties. Specifically, RESPA is going to cover 1 to 4 family residence lots and mobile homes. If you're buying a unit that has 5 or more residents, then RESPA doesn't kick in. It's only for that 1 to 4 units. It's going to kick in for those lenders. This deposits are insured by the federal government. And RESPA is sometimes referred to as Regulation X. If RESPA is X, does anybody remember what TILA is?
Z.
Z. Yep. So RESPA, they gave X, TILA, they gave Z. I don't know why they threw them at the end of the alphabet, but there they are. RESPA does not apply to all mortgages. Like we said, anything 5 or more units, a mortgage or a loan, I should say, for commercial, a business, or agricultural. So primarily, we're just looking at those federally related loans when we're working with our buyers. Those are going to be covered under RESPA. Also understand too that TRID is a lender law. So if your buyer is a cash buyer and there's no lender around, then there's no TRID around. The attorney is going to run that show. So it's only kick in, it only comes in when we have a lender involved. I can think of several occasions over my teaching career, and I had peers that come back from closing just fuming, and they had smoke rolling out their ears, and they're like, I need to know who to call. And I'm like, what are you talking about? And they're like, that attorney put buyer and seller at the same table, and TRID says they can't do that. I'm going to call and complain, and rah. And I said, well, was it a cash buyer? Well, yeah. Well, then can attorney put buyer and seller at the same settlement table together? Sure, because without a lender, the rule is there are no rules. So keep that in mind. What I'd like to do now, if you turn with me to page 476. And what we're going to do now is talk specifically, not all the ways that RESPA protects the consumer, but we're going to talk specifically about 7 things that RESPA does to protect the consumer. So you have the abbreviated version, kind of the Cliff's Notes, if you will, on page 476. And then after that, you can get into a little bit more detail if you need to throughout the rest of the those next couple pages in chapter 14. So the first thing that RESPA does to protect the consumer, they require the lender to issue a borrower credit for a yield spread premium. So let's talk first about what this yield spread premium is. If the lender has a premium, has an amount to be paid for making a loan with an above market interest rate, it used to be that they passed that cost on to the borrower and let the borrower pay that. And RESPA came in and said, yeah, no, the borrower shouldn't have to pay that. That benefits you, lender. The borrower shouldn't have to pay that. So if you do have that cost for that yield spread premium, for that higher premium, then you need to turn around and give them a credit for that at settlement. The borrower is not going to be responsible for that cost. So if there is anything towards the loan origination fees that could fall into that, then again, RESPA now says that the lender's got to credit that back to the buyer. By the way, the lender's yield is kind of like their rate of return. The higher the yield, the more sellable the loan is on the secondary market. So why a lender would want a higher yield is to have a more sellable product when they go to sell that to Fannie Mae, Freddie Mac, Ginnie, whomever. So we take that cost off of the consumer, put it back on the lender, or put it on the lender. Another thing that RESPA does to protect the consumer is they require loan servicing disclosure. When we talk about loan servicing, all we're saying is whether or not the loan can be sold or not. Who is going to service it? Are we going to keep it in-house? Are we going to sell it and let somebody else service it? So the borrower deserves to know whether or not their loan is going to be sold after it's originated. If their loan is sold after it's originated, then they need to be notified. They need to be notified by the one that sold the loan, and they need to be notified by the one that acquired the loan. Lenders, some lenders keep their loans in-house, service them in-house. I think most lenders sell their loans to the secondary market, and it's just to replenish their funds. Lenders don't have some kind of endless supply of money. Lenders have to get the money from somewhere to give to the consumer. So if I'm a lender and I have this much money and I give you, and you a loan, I have no more money to give out. But if I sell your loans, I replenish my funds, and now I can give you, and you a loan. It helps keep money flowing in the economy. It helps keep the lender originating loans. So again, whether or not it can be serviced must be disclosed. If it is sold, then it needs to be notified to the borrower. The third thing RESPA does to help protect the consumers is they put restrictions on the escrow account. Now, there's two different restrictions. The first one is going to be how much they're allowed to collect monthly once the loans originated. So we know your monthly mortgage payment is 4 pieces: your principal and interest, taxes, and insurance. Your taxes and insurance are always going to be a 12th of this year's bill. So whatever your tax bill this year, divided by 12, and that's what you're paying into each month when you pay your mortgage payment. Same thing with your homeowner's insurance. The restriction on the lender here for this slide is that they can only collect a 12th of this year's taxes and a 12th of this year's insurance. Is there a really good chance taxes and insurance can go up next year? Yeah. Especially after all our home values went up. Y'all hang on to your hats for when that tax bill comes out next year. It's going to hurt. As that tax bill goes up, then they can recalculate that 12th. My homeowner's on the call. Sometimes we see our mortgage payment go up. Sometimes we pay in more next year than we had to this year. Mine just went up a couple months ago. It wasn't because of my principal and interest. It was because of my taxes and insurance. So it can be recalculated annually. And they can only collect a 12th. The second piece of the escrow account restriction is in regards to how much the lender can collect at settlement from the borrower to originate their new escrow account. So at settlement, the lender's going to want to collect some money to have as a cushion. We got to originate your escrow account, and then we want a little bit in it in case taxes and insurance go up next year. We have that money in your account to pay those bills on your behalf, and then we'll recalculate how much you're going to pay next year. The restriction, it says that they can't collect more than 2 months of each, taxes and insurance, at settlement, just for the purposes of that cushion. We'll see this again. This is part of the math that we'll do in just a second when we look at our settlement statement. The fourth thing that RESPA did to protect the consumers, and this is the one that hurt us. It hurt us bad. They said, the ride's over, guys. No more kickbacks or referral fees to or from settlement service providers. Settlement service providers are those that provide a service during the contract to closing process. Are real estate agents settlement service providers? Do we offer a service during contract to closing? Yep. Lender, home inspector, surveyor, attorney, pest inspector. Remember all those gears? All those providers on those gears are considered settlement providers. If they are offering a service during that period, and RESPA says we can't give or receive. That's the important part. Somebody could try to offer you a kickback, but you can't take it. It used to be that, for example, home inspectors may say, for every buyer you send me, I'll give you a $25 Amazon gift card. There were stories of lenders, and I can't not make this stuff up. There used to be lenders that would say, for every borrower you send us, we're going to put your name in the hat. And at the end of the year, we're going to do a drawing. And if we draw your name, you are going to win a free 5-day cruise. Heck, yeah. Why am I sending my buyer to this lender? Because they're the best lender in town? I don't care. I want my name in the hat for a cruise. I want them to go to this home inspector for my $25 Amazon gift card. Can we see where we don't always have the consumer's best interest in mind? And RESPA said, stop. We're not going to do that anymore. Specifically, they say anything of value. Y'all, I can't accept $1. I can't accept a donut for recommending services. All I can do is, when I send that home inspector, my buyer to that home inspector. All he can do is say, thank you. And that's it, you guys. Now we know you guys in offices, and we got people that come by your office. You guys got people that swing by and drop off a box of donuts. They love to bring us donuts, don't they? Or maybe some bagels or a bag of candy or something. The lender or the home inspector can come in and say, here's a box of donuts and a stack of my business cards. I'm going to put these in the break room. Y'all help yourselves. Call me if I can help. They can do that. What they can't do is come in with a box of donuts and say, you, and you get a donut because you sent me business last month. If you want a donut next month, you need to send me business. Do we see the difference there? They can do something for all of us. They can't be specific just for one of us. Yeah, Richard.
Does this apply regardless of whether there's a mortgage or it?
RESPA only is around. RESPA is a lender law. So if it's a cash buyer, get your $25 Amazon gift card.
Okay.
This is only a lender law. That's right. Again, this hurt, y'all. I remember when this came out, agents were mad. And it kind of makes you wonder, again, why were they sending their buyers to this person? Was it because they were doing a good job? Was it because they were the best that they had to offer? I don't know. We could argue that point all day. But what I do know is getting something in return is always a nice little perk. The other big thing that came from this, what in practice, I think what we're seeing more and more is giving the consumers choices. You know, here's a list of 2 or 3 home inspectors that I've worked with in the past, or agents in my firm have worked with in the past. If you don't know home inspectors yet, kind of give them options. I think the average buyer doesn't know a home inspector. The average buyer doesn't know a pest inspector and, you know, all those services. So they're coming to us for recommendations, but never look at a buyer and say, this is the home inspector you're going to use and you're going to like it. So give them choices. And if they want to use somebody off your list, that's fine. It's their home inspection. Comments on that? The good news is it didn't touch our agent to agent referral fees. If you're sending a buyer, if you're sending a piece of business to, let's see, Taylor, you're in Wilmington, right? So let's say your best friend wants to move to Wilmington. I'm going to call Taylor. I'm going to say, Taylor, will you help my friend buy a house in Wilmington? And Taylor's going to say, yeah, I'm going to get a referral from Taylor, right? Because I sent her business. Business typically doesn't fall in your lap. So I'm going to say, Taylor, this is what I want to collect. As long as my license is active and current, I can be paid an agent to agent referral. Thank you, RESPA, for not messing with that. The other thing that they kind of came from this too was disclosure of affiliated business arrangements, letting the consumer know if you have some kind of business arrangement. For example, we're seeing several different providers under the same roof. So you may have in one building a real estate firm, a lender, and a closing attorney. Well, we're sharing rent, we're splitting the bills, we have some kind of business arrangements. I still cannot make you use this lender and attorney, but if you do, the consumer has a right to know that we're in business together. The firm I used to work for, actually, they shared an office with a title insurance company, and they provided us a form just to disclose to our buyers that if you go with this title insurance company, we're related, we're affiliated. So it's just about disclosure. The fifth thing that RESPA does to protect the consumers is they offer this Know Before You Owe booklet to borrowers. Now, this is supposed to come out within 3 days of the loan application. We're going to break down what the loan application means in just a bit. Most lenders today use some kind of software, some kind of program. It's kind of like what our doctor's offices are using. So they send you an email and they say you have a secure message in the system, and then you have to go somewhere else to log on to read the message. You guys know what I'm talking about? Lenders may use that program now too, because it allows them to see when the borrower logs on. It allows them to see when a borrower views a form and looks at the Know Before You Owe booklet, that kind of thing. So we can make sure that they are in compliance within that 3 days of loan application. This just walks the borrower through the contract to closing process, things that they should consider, encouraging them to shop around for different services, etc. Again, it's all about educating the consumers. That's a big part of what the Consumer Financial Protection Bureau is about. Also, within 3 days of loan application, the sixth thing that RESPA does to protect the consumers is they now require within 3 days of loan application, the lender to sign a loan estimate, formerly referred to as a good faith estimate. And again, we're going to break down that loan application so we know when that 3-day clock starts. We'll see that in a second. Actually, I don't think we do. I think we're going to see that right now. So turn to page 480, if you will. And on 480 near the top there, you see 6 different items. There's the applicant's name, gross income, social security number, address of the property, value, and requested loan amount. 3 pieces are about the people, 3 pieces are about the property. Once the lender collects those 6 pieces, they have the loan application and their 3-day clock starts. We can only get so far in the loan application until we get a contract, right? So we can get the buyer, we can get the borrower moving through, but until we have that contract, that property in our hands, this is kind of on hold. But that loan application, those 6 pieces, triggers that 3-day clock. We're going to see a sample loan estimate in just a second too, talk more about that as we get closer to our CD. The last thing that we're going to talk about that RESPA does to protect the consumers is require a closing disclosure. Specifically, how many days prior to settlement does the lender need to send? Do we know that? You can show me. Yep. 3 days prior to settlement, the lender's required to send this closing disclosure. Again, we will talk more about this as we get going in Unit 14. So just kind of give us an idea of what RESPA does to help to protect the consumer, what their role is in that. So gee, Julie, what's the big deal? It's only a $25 Amazon gift card. What's the big deal? Well, I'm going to say penalties for violating RESPA can get pretty harsh. You could be looking up to $10,000 per violation. How's that $25 Amazon gift card looking now? You could get to go to jail for a year. An injunction is a legal stop. If the court puts an injunction on you, you're not working while this is being investigated. You could also be looking at civil lawsuits. It's not worth it, you guys. Again, that home inspector may try to offer you something. If we were to go back to that slide, it says give or receive. So even if they offer it, you have to say, no, thank you. Unless it's more than $10,000. I mean, then we can talk. So I can afford that RESPA penalty, right? Spend a year in the big house with the little windows. I don't know. But to me, it's just not worth it. I don't know that many people are trying to do it much anymore. I'm sure there are, of course. But I think we're all pretty much on board with this now. And as a licensee, don't think that the North Carolina Real Estate Commission won't get involved. This could be action for disciplinary action as well, cause for disciplinary action. So now not only do they have an injunction on you, now they've disciplined your license. It's not worth it, you guys. What questions do I have? Comments?
Hey, Julie, I have one. Going back to number 1, I hate to do that to you. With the borrower credit for the yield spread premium. Actually, wait, no, my bad. Hold on. Oh, I'm slow today.
I understand that.
Really slow. Wait, there was something here. Okay, the kickbacks. So with the disclosure of affiliated business arrangements, if you provide that disclosure, are you now able to get
No. All we're disclosing is that we have a business arrangement.
You have okay.
Yep. Nicole, another example. I used to work with a lady, and her husband is a home inspector. So when she was working with buyers, do you think she recommended her husband as a home inspector? Well, sure. But she also couldn't say, you have to use my husband. But if they did use her husband, is there a good chance she could gain from that? I mean, it's her husband, you know, so she just had to disclose. She just had to disclose that relationship. That this home inspector I'm recommending is my husband. If you're comfortable using them, great. If not, we'll find you another one. It's still their
Okay.
choice, but it's about disclosure.
So just a disclosure form, that's
Yep.
it, that's,
Yep.
okay.
FYI them. Yep. And again, if your firm's involved with that, your firm is going to have that form. You guys don't need to worry about creating that. Thank you. Other questions? So just a quick refresher from what we talked about, you know, whopping 30 minutes ago, 20 minutes ago. But again, TRID is the combination of the two. So TIL has always been around, RESP has always been around. All TRID did was integrated them. TILA had their own set of forms, RESPA had their own set of forms. Again, consumers thought they were signing duplicate forms. I just signed this. No, one form's for TILA, the other form's for RESPA. They do two different things. So TRID said, stop. Well, enough with this madness and all this paperwork. If we can consolidate, if we can condense the paperwork, it's going to make it easier for the consumer to understand. So as a direct result of the housing market crash, on October 3rd, 2015, you don't need to know that date, but on October 3rd, 2015, TRID came to be. And one thing that TRID did was combine. Today, we use the loan estimate and the closing disclosure. TILA and RESPA can share those documents. TRID is a lender law, which means it's the responsibility of the lender to make sure they're in compliance. But guys, you and I are also involved with this borrower. We're involved with the lender. So even though we're not a lender, we still too have to make sure we're in compliance with TRID. And we are involved when it comes to that kickbacks and referral fees. So let's talk first about the loan estimate. Various things that we can learn from the loan estimate. The lender will provide the loan amount. They will provide the proposed interest rate. Is there a prepayment penalty? Is there a balloon payment? What is the estimated principal and interest, taxes and insurance? What's the borrower settlement charges? And what's our estimated cash to close? Understand, this is a loan estimate. How many days after application, loan application, are we at right now? Just 3. Y'all, we just went under contract 3 days ago. Can things change? Absolutely. Absolutely. And they often do. This is just an estimate. The lender's just trying to give the borrower a rough idea. With that being said, RESPA has also put, or TRID specifically, has also put restrictions on the changes of the loan estimate that are allowed. So in other words, they're not going to let the lender just throw out any old number and hope it sticks. They have to have some kind of substance to them. Anytime those numbers go down, this is not an issue. If you tell the borrower your monthly payment is going to be $1,000 a month and turns out it's going to be $850, that's good news to the borrower, right? If you tell them 1,000 and turned out it's going to be 1,200, that's going to be a problem for this borrower. So anytime those numbers go down, not a problem. The problem is if those numbers go up. I feel like a lot of lenders are kind of overestimating costs today, which I don't think is a bad thing, but they're overestimating costs just to give that borrower, make sure that they're well covered. So some allowable changes. Again, if anything on the loan estimate, that's our LE, if anything on the loan estimate is less than expected, it's okay. This is good news for the borrower. They don't owe as much as what we originally thought they did. There are some things that are not allowed to change. When the lender quotes their fee to the buyer, once we have that loan estimate, whatever they say the loan origination fee is, that's set in stone, that's stuck. Understand that loan origination fee is a percentage of the purchase price. So could the purchase price change? Yeah, we just looked at our agreement to amend the contract. If you change the purchase price, isn't that going to change what the lender is going to get? What we can't change is what they quoted as the loan origination fee. If they quote 2% of the purchase price, that 2% of whatever the purchase price turns out to be is all they can charge. So that is a no variation. Any lender required services for which the borrower may not shop, that is our appraisal. So whatever the lender tells the borrower, this is your appraisal fee. We said last night, the borrower has no choice whatsoever who we're going to use for the appraisal. It's for the lender. So they can't shop for the services. It's required. Another example of that second bullet point there is the credit report that the lender pulls when they first meet the borrower. And then another thing that can't vary is something called transfer tax. My little asterisk is there because we're not typically doing transfer taxes in North Carolina. Other states may do that. The closest thing that we have to a transfer tax here is the excise tax. And we know that the seller typically pays that. So that's not going to affect the borrower. So transfer tax, that asterisk is telling us that it's not going to be, mostly, it's not going to be affected here in North Carolina. There's also things that can give us a 10% variation, a 10% wiggle room up or down. Recording fees, charges for third-party services. So this is our home inspector, pest inspector, surveyor. We may not know at this point what the home inspector we're going to use and what that home inspector is going to charge. So the best we can do is just throw out an estimate, and we get a 10%, or the lender gets a 10% wiggle room up or down. Again, I feel like they're kind of estimating up to give themselves just that extra wiggle room. Questions so far on the loan estimate and those variations, what can and cannot change? So turn with me in your book, please. It's not a page number, but it's after 493. It's at the very end of unit or chapter 14, 493. So we'll go ahead and make up a page number and call it 494. And hopefully what we're looking at, the page after 493 is our loan estimate, sample loan estimate. Everybody see that? Everybody with me? Okay. So this is our sample loan estimate, 3 days of loan application. So there's your applicant's information, the property and sales price. There's your loan terms. This is a 30-year conventional loan. Let's see, the loan amount of $162,000, proposed interest rate. There's your proposed monthly and interest payment. Is there a prepayment penalty? Yes or no? Is there a balloon payment? Yes or no? It's pretty easy to see, isn't it? Even the borrower that has no idea how a mortgage or a loan works, they can look at that pretty clearly and see those numbers. Can this change? Yes or no? Is this a thing? Yes or no? It's hopefully helping the consumer better understand this commitment they're about to make. Under that, we have your projected payments. So it's projected that your estimated escrow and mortgage insurance, PMI, of $1,050. And then kind of near the bottom there, we have our estimated closing costs and our estimated cash to close. Within 3 days of loan application, our borrowers now know that when they go to closing, they are going to bring about $16,054. I can't tell you guys how huge this is. Prior to the housing market crash, not all borrowers were seeing this. In some cases, you guys, I wasn't in sales yet, but I heard about it through my agents. In some cases, borrowers weren't seeing their numbers until they were at the attorney's settlement table. I mean, that always makes my heart flutter a little bit. Is that not the most terrifying thing? You're getting ready to sign a 30-year commitment, and you don't know until you sit down what you're looking at. That doesn't seem fair, does it? Now we're giving them the opportunity to review this, to look at this, to make sure they're good with this numbers within 3 days of loan application. Yes. Do that. Nicole survived with me too. Yes. I sometimes feel like I should have a t-shirt that says, I survived the housing market crash. You know, it was
I
tough.
switched
It was
over to commercial in '07
hard.
because you could see it coming here.
Yeah.
This was like a whole condominiums were selling out in 24 hours. Like it was absurd, absurd.
Yep. Yep. I was still an admin then. I tell you guys, because I mean, unfortunately, you guys, agents were getting out of the business, lenders, appraisals. I mean, we lost a lot, professional. And guys, I'm telling you, when I went to work every day, first thing I would do before I even started the coffee, the first thing I would do is walk up and down the halls of the office and see who moved out last night, who cleared out their office, who cleared out their cubicle. So when my bit got to work, I could meet them in the parking lot with the good news about who's gone. It was like that. It was tough. It was tough. So hopefully the whole point of this, guys, real estate's a market. We're always going to have highs and lows. It's a market, markets fluctuate. The whole point is that our lows don't get that low again. So helping to educate the consumer. The next page, we'll call it 495. Again, we don't just say, you got to bring $16,054. The next page gives you the breakdown. If you were to whip your calculator out and add up all those numbers, it's going to add up to $16,054. So don't just say this is how much you owe. This says this is where all this comes from. This is the breakdown of that amount. So when it comes to this loan estimate, what's our responsibility? Well, we have to have this general knowledge about TRID. We can help the lender communicate with the borrower. So when you send that contract, remember buyer's agents, we go under contract, yay, send that contract to the lender, and then we can talk to the borrower. You're gonna get communications from the lender. The lender's gonna send requests, they're gonna need documents, they're gonna need you to submit them stuff. They're also going to send you a loan estimate, so be on the lookout for it. Remember those gears, you guys. We gotta help keep those gears moving. And would it surprise you if I told you in some cases that buyers delayed their own closing because they didn't get the lender the paperwork that they needed on time? So help keep those gears going. Tell the borrower, I need you to get the lender what they need because they can't process until they have whatever they're requesting. So this looks like a good stopping place to me. So let's go ahead and take our first break. When we come back, we're going to talk about the closing disclosure. back. I am taking attendance. We've talked about the loan estimate. So now let's fast forward to settlement or closer to settlement and talk about our closing disclosure. One thing that came from TRID, we now have 2 closing disclosures, 2 settlement statements. It used to be they put buyers and sellers all on the same. Sellers could see buyers' loan financial information. Sellers could see all of buyers. Buyers could see sellers. TRID said, yeah, no, that's why. We need to keep these separate. So today we have 2 closing disclosures. The lender is in charge of the borrower's closing disclosure. The lender has no relationship with the seller. So the lender is only in control of the borrower's CD. The seller will have a CD issue, but that's going to come from the attorney, and that's going to come like the day before or the day of settlement. It's going to be right at it. There are no regulations. Understand when we talk about TRID, when we talk about the consumer in this transaction is the borrower, because they're the ones originating a new loan. So that's who we're protecting. The seller may have their own loan, but they're not originating. Yep. So we have 2 CDs now. So let's talk specifically about the borrowers, what the lender is going to do for the borrower. Like we said, TRID only applies if the lender's involved. The consumer in this transaction is the borrower. That's who we're protecting. Any money that changes hands as a part of this transaction must appear on the closing disclosure. We may have a case where mom and dad want to pay for the home inspection. They are so proud of their first-time home buyer child, adult child, and they'll say, well, I want to do something. What can I do for you? I tell you what, I'll pay for your home inspection. Can mom and dad pay for the home inspection? Sure. We just have to make sure that we disclose that on the settlement statement. If it's about this I don't care who's paying for it. Any money that changes hands as a part of this transaction has to show up on the closing disclosure. I think this is one place that we can help the lender through the process, because we may be standing there in the living room of the home with the buyers and the mom and dad to hear mom and dad say, we want to pay for that home inspection. So when we hear that, it's okay. We just need to let the lender know so they properly put it on the closing disclosure. We know that the lender has to deliver the borrower their CD 3 days, not less than 3 days prior to settlement. This delivery of the CD from the lender to the borrower has to be directly to the borrower from the lender. You and I cannot get involved in that. The lender's not going to send you the CD and say, forward this on to your buyers. That's communication directly to the borrower. So there's this 3-day rule if the CD is delivered personally. So either the lender hands it to them, that's not happening, or they're sending it through that software and they can have them sign off on it, verify that they've sent it to them. If they're going to snail mail it or just email it to them, then we need to allow for 6 days prior to settlement. Most of the lenders that I've ever dealt with have that software, have that capability of sending through that program where they can see where they opened it. When it comes to counting days, specifically the 3 days, we'll stick with the 3 days of the CD. When it comes to counting days, Sundays and national holidays don't count. So when we're counting days for the closing disclosure, Saturdays, assuming it's not a national holiday, counts. And when we count days, the first day begins the day after receipt. So today's Wednesday, is that right? Goodness. Okay, so today's Wednesday. So if your buyers got their CD today, Thursday would be day 1, Friday would be day 2, Saturday would be day 3. Good luck finding an attorney that's open on Saturday meaning we'd probably be looking at going to settlement on Monday. If you get your CD today, there's no way that you could close before Saturday. So we always start counting. The next day is day 1. We can close on day 3, assuming the attorney's open. And when we talk specifically about these national holidays, these are the ones that we're referring to. And again, that count starts the 3 days after receipt. This is another big place that we can help keep those gears going, letting the buyer know we are less than a week away from closing. And you need to be on the lookout for a very important email from your lender. Because if they don't get at it right away, they could delay their own closing. Remember we talked last night about how delays in closing are just, they're common, they just happen. What's another reason we could have a delay? It could be to deal with this lender law right here. If they don't have that CD to the borrower within 3 days of settlement, there's nothing we can do. There's nothing the attorney can do. There's nothing that the lender can do. They have to have that in their possession, in their hands for 3 days. The lender kind of drives the show. The lender is the one that tells the attorney how they want to handle things. The lender is the one that tells the attorney that we want 2 CDs. The lender doesn't want the seller to see the borrower's sensitive financial information. And then, as we said, delivery of this CD is straight to the borrower. You and I can't get involved in this. This is the one place that we cannot communicate. So the lender, that communication with that CD needs to be straight from the lender to the borrower. Sometimes after that closing disclosure is issued, we may find an error that we need to change, or we may need to, maybe we forgot to add something, or maybe they need to fix something. When we get that CD 3 days prior to settlement, that may not be the end all be all. We're just trying to satisfy those TRID rules. If we do have to make a change to the CD, we generally don't have to have a new 3-day count. So let's say your borrower gets a CD, you forget because you're really busy, and you forget to send the attorney the home inspector's invoice, and you're reviewing it and you see it's not on there, you go, oh my gosh, I forgot. Or you forgot to send in the amendment to change the due diligence amount or the earnest money. It's okay. We have a duty to report that, and you're not going to delay closing for a change like that. There are only 3 things that are going to cause a new 3-day count. So we issue the CD 3 days prior to settlement, and then for some reason that APR goes up, annual percentage rate goes up, but more than an 8%. There's a change in the loan product, or there's an addition of a prepayment penalty. If any of these things happen, then the lender issues a new CD and we have a new 3-day count. But these are the only changes that will require a new 3-day count. So any other change does not require that new 3-day count. And this could even include changes after that deed's been recorded. Again, no need for a 3-day count. So let's talk in practice for a second. TRID's the lender law. TRID says you have to have it to the borrower 3 days prior to settlement. We're all good with that. The borrower is not going to the bank to get their readily available funds based on the CD they received from the lender. They're just signing off that they've received it. It's not the final CD. It's the final CD, not the final. Once the borrower signs off on it, then the lender and the attorney come together and put their finishing touches on it, make sure they have the property prorated taxes, for example, that home inspection invoice. The attorney then sends us the closing disclosure for us to review. We'll talk a little bit more about our responsibility in reviewing that closing disclosure. Our responsibility for reviewing it for accuracy. If we find a mistake, then we need to make sure that we report that to get it fixed. You and I may not be seeing this CD until the day before settlement. They've signed off on the CD from the lender, but now you and I are getting a chance to review it the day before. Once we review it, we're the ones that tell the buyer how much to get from the bank. We're the ones that tell the buyer, go get a cashier's check for X amount, or do a wire transfer for X amount. So you and I, one of the last few closings I've had, the lender actually sent an email to the buyer and CC'd me and said, I'm about to comply with TRID. I'm about to send you your closing disclosure. Big, bold, and all red. Do not go to the bank until you've talked to your agent. Thank you, lender. That helps me help you. That helps ourselves. So make sure your buyer knows what you get from the lender is going to be awfully close. But until we put those finishing touches on it and get down to the penny, that's when we're going to send you to the bank. So let's go back to our books, our unnumbered pages there at the end. And after the loan estimate in chapter 14, if you flip the page, we also have a sample closing disclosure. Let's fast forward one more time. Loan estimate to the closing disclosure. This is the same borrower with the same loan information. You can see if we were to compare the loan estimate, we had a loan for $162,000 with 3.875% interest. There's your projected monthly principal. That's the same. Your projected payment went up 26 cents. I don't think that's anything to get too excited about. That's probably, now that we know insurance, now that we know taxes, it's probably what that is. And then check that out. Under the loan estimate, we told the borrower you're going to have to bring $16,054. Now that we're actually here at settlement, they only have to bring $14,147.26. Isn't that good news for your buyer? You told them 16. Now they're only bringing 14. There's some wiggle room there for them to go get like paint or, whatever. When you guys buy a house, you're going to go to Lowe's a lot. And to have that extra money will help with those Lowe's trips, So this is good news for the buyer. We can do a nice side-by-side comparison. The next couple pages there, the CD that we're getting ready to spend some time on. But I want you to look, man, I don't know why I don't have a page number, but it's the top of the next page. And it's a little section that says calculating cash to close. And you can see that calculating cash to close, there is a nice side-by-side comparison for the consumer. This is what we told you at the loan estimate. This is what we told you at the final. And did this change? Simple yes or no. Isn't that easy for the consumer to see, the consumer to look at? They may not remember what they got 4, 5, 6 weeks ago when we went under contract, but they offer them this nice side-by-side comparison to consider those things and look at those, any possible changes. Again, those couple pages there, what we're getting ready to do. So I'm not going to spend time here, but no, as you guys are learning these CDs, you have kind of a sample here and you can see how one is in motion, how one works. And understand too, closing disclosures are just that. They're disclosures. We still have to have a settlement statement. The problem, and I don't know why, but the problem with the CD is it doesn't authorize the attorney to pay anybody. So all we're doing is just spelling out the numbers, pointing out the numbers. The settlement statement is what authorizes the attorney to pay me and you, themselves, the seller, etc. The most common settlement statement is the ALTA, but attorneys can pretty much use, whatever settlement statement they choose. Richard, back to our cash buyer, the ALTA is probably all you're going to see. You wouldn't have a closing disclosure from the lender, just that ALTA. And again, the attorney can choose to do what they want to. The numbers are going to be the same. It's going to shake out the same. It's just authorizing the attorney to pay everybody from their escrow account. So let's bring this home. What does all this mean for us? Well, we have a duty to make sure that our buyers, the CD that they receive is accurate. Our sellers too, by the way, but specifically talking about our buyers to make sure that those numbers are accurate. When we find an error, we need to make sure that we're reporting that to the lender and the attorney so they can make it fit. They can make it right, fix it before settlement. I wish I could stand here and tell you guys that these things are always right 100% of the time. I'm not a liar though, so I'm not going to stand here and tell you that. People make mistakes. That's just plain and simple. And the thinking is the more sets of eyes that are on this thing, the better chance for accuracy that we have. So making sure that we understand these things so we can check them for accuracy, that's a big part of what this class is and what we're doing. So we can help with that. There's several different methods, depending on your pre-licensing school. There's several different methods for teaching the duties and responsibilities we have to our clients. So some of you, do I have any old car people out there? Where are my old car people? Some of you may be loads, LOADS, but I think most of us are old car. Who can remind me what that A in old car is?
Accounting.
Accounting. That's a big duty we owe our client, is to help them account for their funds, account for their money. Doesn't verifying the closing disclosure directly fall under helping our clients account for their funds, account for their money? Absolutely. Making sure that those final numbers are right, making sure that what the seller hopefully is going to get from closing is correct, making sure what the buyer has to bring from closing is correct. So big responsibility we have. And again, when we find a mistake, then we need to notify the lender so they can make the changes. Failure to report these errors could result in willful omission. It could be seen as a disciplinary action. If you're new and you're not familiar with settlement statements yet, the first couple that you review, get with your BIC. Let your BIC sit down and help you go through those numbers. Once you get through a few of them, then you're going to start being better at being able to calculate those. And again, that's the section we're heading into next. So you guys will know how to look at those. Questions or comments?
Yeah, so I guess like we talked about yesterday, I'm used to escrow companies. So an escrow in Nevada, the escrow company would work with the lender and they kind of go back and forth to agree on a settlement statement.
Okay.
And then it comes to us. But here, what happens? The lender and the attorney go back and forth to agree, and then it comes to us?
Yep.
And then help me understand the step between the CD and the ALTA. Who's
So
doing
the
what?
lender sends that CD to the borrower 3 days prior to settlement, and then they are in communications with the lender. So, getting like again, we may still have a, idea of taxes, but the the attorney's going to have like down to the penny of taxes, right? So it's just making sure that the two's numbers are in cahoots. And
Yes.
after they work out, that's when the attorney sends us the CD to review.
So once the attorney and the lender agree on a CD, I guess, then the attorney says, okay, between then and now, 3 days later, this has changed, and so I need to tweak it here and there, and that becomes the ALTA, and that's the responsibility of the attorney.
The attorney, yes, the attorney does the ALTA. So once we get those numbers and everybody's good, then the attorney, and they got a system, they just beep boop boop, and it just pops it out.
Okay, and then
Once they have those final numbers.
where does the real estate agent get involved and have any kind of liability on the correctness of it, other than checking the math?
Exactly. And that's what our responsibility is. And we're talking just in this next section, Richard, about the numbers that I can verify, the numbers that I don't know. I can't verify all of the numbers, but I do have a responsibility to verify the numbers that I can. So for example, can I verify the purchase price?
Mm-hmm.
Sure. Can I verify the earnest money, the due diligence? Those are the kind of things that I'm going to be responsible for, making sure checking them for accuracy.
Okay, and maybe the proration of taxes, those simple math stuff you can.
By the time I'm done with you guys, you'll know how to prorate taxes. You'll know how to calculate interim interest. So
Right.
when you get these CDs, remember that basic calculator I got you guys by? You can whip that thing out and add it up and make sure that those numbers, again, that I'm not responsible for all of them, Richard, but I do have a duty to review what I can for accuracy. And I always need to be on the lookout for little red flags. If something doesn't look right, say something.
Yeah, the reason I asked is because in Nevada, we didn't have to deal with this sort of math on settlement statements. I guess maybe that's because it's incumbent upon the escrow company. That's their
Different
lane
companies.
and not our lane. But
Could be.
so I was worried that, since we have to do this kind of math, maybe we're held responsible for something other than simple math.
If we don't verify, we are. And maybe Nevada's real estate commission is different than North Carolina real estate commission
Yeah.
too. So where the differences lie, I don't know, but yep. In other words, you guys, we can't just say, oh, I got it, and I'm sure it's right, and I'm not gonna worry about it. We got to look at it. We got to put our eyes on it. Yeah, Nicole.
I feel like the biggest voice tonight, and I'm sorry about that. I'm looking through your slides, and what's the difference? Like, I see 3 business days, and then I see the 3 days and what we discussed regarding the Sundays and national holidays. So what distinguishes between the 3 business days and just the regular 3 days?
Well, some places Saturday is considered a business day, so don't let that mix you up. For counting CD purposes, a business day is Monday through Saturday. So all we're excluding for that is Sunday and major holidays. Like if we were counting contract days, a day is a day is a day. So Sunday counts, Christmas counts, everybody. But specifically for CD days, Monday through Saturday counts as a day for that 3-day count.
Okay, but some slides say 3 days and others say 3 business days. So I just
That's
wanted
probably
to.
just my inconsistency. So, but for CD, how we count days, yep. So a bit, like I said, some banks are open on Saturday, yes. So some banks can consider Saturday a business day. So through the eyes of the lender for that CD, Monday through Saturday is counted as a day. And we always start counting the day after receipt. Okay, so here it is, the last piece of chapter 14, the settlement statement, closing disclosure used interchangeably. So we're going to go through and talk about a few things, and then we're going to get off PowerPoint, pick up our calculators, and actually start specifically looking at these closing disclosures. So first off, though, we need to define some basic closing disclosure terminology, making sure that we understand the words. We're going to talk about what a proration is and how we can do it. And then, of course, the star of this section, we're going to calculate that closing disclosure. So let's start with some basic terminology so we can understand a few things. The good news is with these, we're only dealing with debits and credits. So a debit is money going out. A debit is considered a charge against somebody. It's money that somebody owes. A credit then is money coming in somebody's favor, on somebody's behalf. Think about if you were, let's see, it's going to be late tonight. So if you were to go out tomorrow for lunch and you pull out your card, swipe it in the machine, how does it show up on your account? It shows up as a debit. It's money going out. It's money that you owe that vendor that you gave you lunch. You come home for lunch tomorrow, you check your mail, and there's a bonus check from somebody in the mailbox. You immediately go in and deposit that check. How does that show up in your account? It shows up as a credit. It's money coming in. Do I have any accountants on the call? Good. Accountants struggle with this because in accounting, debits and credits mean something totally different, and we have to kind of unwork that. So good. We're starting off good there. So debit, money going out, credit, money coming in. Prorations, there's a couple different things that we're gonna prorate between buyers and sellers. First off, the idea of prorations. I'm taking a shared expense and I'm making it fair. If you buy my house today, it's November 29th. If you buy my house today, is it really fair for either one of us to pay this year's taxes? Is it really fair for either one of us to be responsible for the entire year? Well, not really. I mean, I'd have the majority of the year, right? I'd have the first 11 months, but I don't want to pay next month because I'm not going to own the house. So how do we make it fair? We're going to prorate. In North Carolina, typically when we prorate, we're going to consider the seller responsible for the day of closing. And what I mean by that is the seller is responsible for today's taxes, today's HOA dues, for example. I always think of it this way. When we woke up this morning, when our alarms went off this morning, the seller still owned the property. So they get to pay today's taxes. Fingers crossed, if everything goes according to plan today, when we wake up tomorrow, the buyer now owns the property, so their responsibilities will pick up. Please note, this second bullet point is a major problem topic. So I want everybody to read, see this very carefully. The seller is responsible only when we're prorating, only when we are dealing with a shared expense. Sellers have their own expenses on their own. Buyers have their own expenses on their own. Each party is responsible for their own expense. But when we have this shared amount, when we're prorating, that's when we consider the seller responsible for the day of closing. So most common things prorated, this year's property taxes. If the seller never paid 2022 taxes, that's entirely on them. The buyer has nothing to do with that. So we're going to prorate, we're going to share this year's taxes. If the property's in an HOA, has a HOA dues, we're going to share that expense. Maybe they're monthly, maybe they're quarterly, maybe they're annually, but we're going to share that. Yes, ma'am.
If the seller never paid the taxes of the prior year, aren't they due at closing?
Absolutely. And that'll come out of their proceeds before they get paid, Selena. That's kind of the thing that the attorney's going to find. You better believe it. Yep. The other thing that we may prorate is rent. If the buyer, if the buyer's buying a property with a tenant in place, today the seller's the landlord, tomorrow the buyer's the landlord. So we got to share this month's rent. We're going to look to break this down and talk about it. And there's a couple other things too that can be prorated that we'll look at. For example, I think something that we're getting ready to see come back, or not come back, but come into our market and kind of sweep us away is going to be buyers assuming sellers' loans. And if a buyer's assuming seller's loan, we're going to share this month's interest, in which case we need to prorate. So we'll talk a little bit more about those examples. Right now, to introduce us to prorating and to get us in this conversation, I just want to focus on this year's taxes, and then we'll kind of address HOA dues, rent, or interest, and that kind of stuff later. So it's one step at a time, right? Understand that a true proration is a debit to one party and a credit to the other for the same amount. Somebody is giving somebody some money. Somebody owes somebody some money. Now, let's put closing and real estate aside for a second. Pretend that they don't exist. If I owe you money, let's say I hand you a check. When that check leaves my hand, it's a debit from me, right? It's money coming out of my account. It enters your hand as a credit, right? That goes into your account. And the amount on the check stays the same. I am handing you money. Now let's bring closing and real estate back into it. Buyer's not handing seller a check at settlement. That's not how that works. Instead, we're going to hash it out on the settlement statement as a debit to one party and a credit to the other. We may also have a scenario of a double debit. We'll talk more about that as well. The double debit says that the attorney collects from the seller, the attorney collects from the buyer, and then the attorney sends one check in to the county on behalf of the property. So buyer nor seller are paying taxes this year. The attorney's collecting from both, double debit the seller, debit the buyer, and then the attorney's going to pay taxes this year. Usually this is most common if taxes have not been paid and we're like this time of year. We're awfully close to the end of the year and we just want to settle that up. Does the county care who sends the check in for this property this year? Nah, they don't care where it comes from, just so long as they get that money. So we'll look at some examples of that as well. When we prorate, pre-licensing world is over. Remember that 30-day month, 360-day year? That was nice, wasn't it? Well, welcome to the real world. Now we're dealing with actual calendar days. We're going to talk about those days using a 365-day calendar. Next year is a leap year. Keep that in mind because now we're looking at 366 days next year, but we're not there yet. And as we said, the seller's responsible for the day of settlement. For your exam on Saturday the 9th, when we start your exam, I'm going to put the number of days of each month in the chat. So you guys have that. Because quite frankly, I want you guys focusing your energy on chapters 11, 10, 11, and 14, and not how many days are in March. To me, that's not the important part of this test. So I'm going to give you that. I'm going to tell you how many days are in each month, so you don't need to worry about that. Is that good? Is that fair? I know there's a rhyme and you can do the little knuckle trick, but whatever. Focus on prorations, not on days. Okay, so we'll do that for you.
When I was in pre-licensing, we were told that real estate does a 360-day year. Is that not true?
Not anymore. We're out of pre. Now we're dealing with the actual number of days and a 365-day year.
Okay, got it.
So a couple different scenarios when we prorate. We need to read the problems and see what it is that we're dealing with when we prorate. So let's break these down. One scenario of prorations. Taxes have been paid by the seller prior to closing. We go to closing on, let's go today, what the heck, November 29th, and seller has already paid this year's taxes. On the closing disclosure, that's going to shake out as a credit to the seller and a debit to the buyer. When I prorate, I'm a visual person. I like pictures. I like to see what it is that I'm dealing with here. So when I prorate, I like to draw myself a timeline and I like to see what it is that I'm prorating. So my timeline goes for the year. What divides the timeline is the day of closing. Let's go to closing today. What divides the timeline, we know the seller owned the property the front part of the year. The buyer will own the property the latter part of the year. So I gave myself a visual. I gave myself an image. And when you guys prorate, I'd like you to write something down for me. I want you to ask yourself, who owes who? Because when you see that taxes have been paid for the whole year, we need to stop, think, close your eyes if you need to, and ask yourself, who owes who? And our timeline can allow us to see the seller has already paid taxes for the entire year. So who owes who? I see mouths move. The buyer owes the seller. How's that going to shake out in CD language? Debit to the buyer, money coming out of the buyer's hand, credit to the seller, money going in. The seller's credit, what they're going to get from the buyer as settlement, is the period of time that the buyer owns the property. Remember, who's paying taxes today? Who's responsible for taxes today? The seller. So the buyer's responsibility is going to start tomorrow and go through the end of the year. So if we were to count this out, we would have 1 day left in November, 31 days in December. So how many days does the seller owe the buyer for taxes? 32 days. I think the timeline helps. I think it allows us to see what exactly it is we're dealing with, who owes who, and what portion of the timeline. When you guys are doing prorations, the other thing we can see from the timeline that I think is helpful, before you ever touch a calculator, who has the bigger responsibility in taxes this year? Who has the bigger amount, the bigger responsibility? Seller. So think things out sometimes. Whose amount's going to be bigger? The sellers in this case, because they own the property for more. Once we know how many days, you just take your annual taxes, which in our case, the problem will have to tell you. Take your annual taxes, divide by 365 to give you daily taxes. That daily amount times 32 will show up on the settlement statement as a debit to the buyer and a credit to the seller. So one scenario, we get to closing. Keep in mind, you guys, at this point, it's going to have to be after September 1st, isn't it? It's going to have to be after September if taxes have been paid. Why am I saying that? Julie, what are you talking about? Why am I saying it's after September?
Because that's when it becomes due. You don't get it.
That's when we,
Yeah, you don't
That's
get
when
it
we-
until July, but it becomes due in September, and then it's overdue on January 6th of the following year.
next year, that's right. Guys, until we get that bill, we don't even, there's no way that taxes could have been paid. Is everybody with me? So if closing's after September, I don't know when closing is, but I know it's got to be after September because, thank you, Missy. Prior to that, they haven't even calculated this year's taxes until like July. So we don't even know what they are now. By the way, if we're going to closing before September and we don't know taxes, what are we prorating? I don't know how much you owe in taxes this year. What are we going to prorate?
It's different in Florida, as I'm assuming it's different in a lot of states. Can you just repeat that for me on when?
Well, hang on, I'm asking you guys a question. If we go to closing before September and I don't know what taxes are for this year, what do we have to go on?
The previous years,
We're going to look at 2022 taxes. I don't know 2023 taxes yet. So you get a closing in March. What can I do about this year's taxes? You guys with me? Could taxes go up and somebody kind of get shorted? Maybe a little bit, but in the big picture, it's going to be nominal when you break it down to daily. But just understand that September, when it comes to taxes, is a very important day. Nicole, I apologize. Thank you.
No, all good. So just so I can write this down. So in North Carolina, tell me taxes are due in September.
Yep.
And then when do there was something about January, I'm sorry.
They are delinquent after January 5th of the next year. Which means they start collecting interest starts accruing. And then the seller goes to pay the house, and 6 years from now, they have a really big.
plus they don't get that tax break when
And
they
they don't
file
get
their
that. Yeah,
tax.
you don't get a break if you're late. So there's another good reason to pay your taxes on time. And guys, remember, if you still have a loan, that's being escrowed and the attorney's handling that for you. But what if you've paid that off? What if you're a cash buyer? Who's responsible for taxes now? Well, I mean, you're always responsible, but who's paying them? You are. That's right. That's right. Take that in mind if you're ready to pay that mortgage off. I was fortunate. I have a little condo in High Point. I was fortunate to pay it off a couple years ago. And the year I paid it off, of course, I got a letter from Guilford County that said, your taxes have been paid. I get that letter every year. Your taxes have been paid. We got you. We took care of you. Last year, I got a totally different letter from Guilford County, didn't I? My letter from Guilford County said, you owe us. The lender was out of the picture. it's fully on me now to make sure I pay them. So just keep that in mind, whether or not a lender's involved in paying those taxes. And that's why things like the buyer's responsible for taxes. I'm not telling you guys the buyer's necessarily paying or the seller's necessarily paying this year's taxes. What we're saying is who is responsible for to make sure that amount gets paid. So taxes have been paid. Always draw the picture so you can see what it is you're looking at, and then stop and ask yourself, did y'all write that down? Who owes who? Because I think, I'll be very honest with you guys, when I prorate, figuring this piece out, who gets the credit, who gets the debit, is the piece that I really have to sit down and think about. And that's where I think the timeline is very helpful. So this is this scenario. Another scenario may be if taxes have not been paid by the seller prior to settlement. So as we just said, could be closing happening in August or March or January. We don't know what this year's taxes are yet. The bill hasn't come out, so there's no way they could have been paid. So again, let's draw our timeline. So I have this year's taxes. And now let's go to closing. Let's go to closing on St. Patty's Day. That's always fun. Let's buy a house on St. Patty's Day. So now we're going to closing on March 17th. Seller's responsible for the front part of the year. The buyer's responsible for the backyard. Don't pick up a calculator. Who has the bigger responsibility this year? Who owes the most money, the bigger part?
The buyer.
The buyer, because they own the property longer. So we know that taxes have not been paid, meaning at the end of the year, the buyer is going to be responsible for the whole year. If the buyer is responsible for the whole year at settlement, who owes who?
The seller owes the buyer for all the way up until the 17th.
The seller owes the buyer from the first of the year, debit the seller, credit the buyer. The seller has to give the buyer at settlement money for time that they owned the property, including the day of settlement. So we have 31 days in January, 28 days in February, and then our 17 days in March. And that gives me 76 days of taxes that we're going to see shake out as a credit to the buyer, debit to the seller. Again, take your annual taxes, divide it by 365 to get daily taxes. Daily taxes times 76 is our entry on the settlement statement. Taxes have not been paid, and closing is before September.
So yeah, sure, I'm understanding. Is the fiscal year of the state January to December, or is the fiscal year June or July to June?
That's the Real Estate Commission's fiscal year. North Carolina state is January to December for taxes. Yep. Each county.
Okay.
The North Carolina Real Estate Commission is July to June. I'm sorry.
So the state comes up with a new tax value in July or so?
Well, the county does.
But
Yep.
the county does?
Yep.
Okay. And then sends you a bill in September that's due in January?
By January 5th.
Okay, okay.
Yep. Have not been paid. Closing is before September. Again, the buyer's going to be responsible for the whole amount when the bill comes out in September, right? The idea, let's consider this. The idea of settlement is to settle everything between the buyer and the seller. We want to finalize everything today. Could you guys imagine a world where we don't finalize this? The bill comes out in September. The buyer calls the seller and says, hey, man, our taxes are due. Send me some money. What's the seller going to say? Duh. And hang up the phone, right? So how do we make it fair? We prorated at settlement. We finalize everything between the two. What this means, this is that much less money that the buyer has to bring to settlement. That's what we mean by credit. That's that much less money that they'll have to bring. The other or another have not been paid scenario, this is what we're looking at before September. But what about taxes have not been paid after September? Are you guys hearing September is important when it comes to taxes? Taxes have not been paid after September. Now we're probably looking at our double debit. So we're not going to prorate. They've not been paid. It is November 29th. Nobody needs to let the lender's escrow take care of it. We just got to get these taxes taken care of. So we would go to closing on the 29th after September. Debit the seller. Their responsibility is January 1st through the day of closing. Debit the buyer from the day after closing. Nobody's getting a credit. Nobody's getting money. The seller's paying their portion. The buyer's paying their portion. And the attorney will send one check into the county. Now, guys, I'll be honest, in practice, attorneys are going to do what they want to do. But for our exam, Saturday is, or September, why did I say Saturday? September is a very important date. I say that, I bought my house in August and they did a double debit for us. Why? I don't know, because that's what the attorney wanted to do. So in practice, you may see some variations. You may see some flexibility. As far as it goes for my clients, I don't care as long as their numbers shake out. As long as their numbers come out and they're owing what they owe. Before our exam, Saturday, or why do I keep saying that? September is that important month. That's that cutoff to know whether or not we're going to do a credit buyer, debit seller, or if we're going to do that double debit. Questions?
I have to say, I'm having a tough time with this. Can I talk to you
We haven't picked the
offline?
calculator up yet, so we're just introducing you to it.
Okay.
Yep. And we got to see it a few times. How many of you just met prorations for the first time tonight? 30 minutes ago. So you got to give it a minute. Yeah. We're just introducing you to it. We are about to pick the calculator up. But simplify it. Taxes either have been paid or they have not been paid. And we got to address this, don't we? We got to prorate it and make it fair for the parties.
Julie, I have a question. Can you hear me?
Yes.
If the lender is charging whoever owns the home, like that amount that gets included in your monthly payment to the lender because they go ahead and break that tax amount up, then in September, wouldn't taxes have been paid on it if you're already paying monthly through your lender?
The lender usually doesn't send that in until the end of the year, Carol. So they're not going to send it in September generally, but and when we're saying the buyer's responsible for it, understanding at the end of the year, they're not going to sit down and write a check. The lender's going to pay that on their behalf, but the lender's generally going to wait until, for our purposes, the lender's going to send it in like December 30th, right? So if we're going to closing after September, the bill's been out, but there's a really good chance, especially, for either one of these, that the lender hasn't paid it yet.
Okay, and you said that like a charge will show up as the same amount and it will be a credit to one party and a debit to the other?
That's a true proration.
So like in the case where, let's say the seller has not paid and is gonna have to pay, there still is an amount that the buyer owes for those taxes for themselves. So
The
like
buyer will.
where does
So
that
if
show up?
So if the seller's already paid, the seller's already paid. So now at settlement, the buyer needs to reimburse the seller. And that's what we're doing with a credit to the seller, debit to the buyer.
Okay.
Let's go back to Carol, you're buying my house today. You're gonna buy my house today. And I've already paid this year's taxes. You owe me some money, don't you? Because you're gonna have this home for 32 days tax-free? I don't think so. So you're gonna reimburse me at settlement. You're gonna reimburse me for those 32 days to make me whole and for both of us to be responsible for the time this year that we lived in the home. Or own the home, I should say.
Okay.
Okay, let's go ahead and take a break. Again, we're just introducing you guys to we're gonna spend more time with this. So take a break, get you some water, big deep breath, and when we come back, we're gonna keep going on our closing disclosure math.
Miss Julie, you still here? Richard. Sorry. Are you able to see her screen?
I can see the clock, 9 minutes and counting down.
Oh, okay. Because all this time, ever since we came back from last break, I don't see anything. I have like a black screen in front of me.
Oh, really? Oh, no, there have been slides.
Like, I'm able to see you right now, like that little square on top, but not anything below. Like whatever she's sharing, I cannot see it.
So what do you see right now?
Black screen.
I would try logging out and logging back in.
Yeah.
Yeah, Bobby, I was just wondering. I was like, maybe that's how it is for everybody, but I'm like,
Try
thank
logging out and
you.
logging in.
I'm doing that right now. Thanks.
Richard,
Yes.
sure as hell gets confusing when you have stuff from different states. Makes it more difficult.
I couldn't hear you with all the ringing. What was that?
Oh, it just makes it a little bit more difficult in different states that we're in, right? Like it's, you have to like rethink.
Yeah, yeah.
You
When-
guys
when-
have the challenge, because you got to stop and ask yourself, what state am I standing in right now? Because that's
Yeah,
where you're
and
gonna
on-
be.
And on the commercial side also, and with the leasing that I do, you know, I don't get involved with this stuff, right? So it makes it even more compounded.
Sure. And like we said, it's new. So,
Yeah.
okay. So let me see. Let me grab attendance real quick before I forget, because I can do that. And I had a question come in the chat during break, so I do want to address that. The question is, will there ever be a scenario when there is a credit to the buyer? And the answer is yes. And that scenario of when we may see a credit to the buyer is if taxes have not been paid, meaning when we go to settlement, it's going to be let's see, when do you want to go to settlement? Taxes have not been paid. So let's go to settlement. Let's pick a date. Let's go on where do we go before? March 17th. It is March. Have taxes been paid? You can shake your head yes or no. It's March. Have taxes been paid? No. So that means somewhere later in the year, the buyer is going to be responsible for the whole year. Yes, it's going to come from their escrow that the lender has set up for them. So that's why we're careful to say not that the buyer is going to pay them, but the buyer is going to be responsible for them. It's going to come out of their account. And at the end of the year, like December 30th, the lender will pay that entire bill on behalf of the lender. So how do we make this fair? At settlement, we do a credit the buyer, debit the seller for the period of time, including the day of settlement that the seller owned the property. So we're looking at what, 31 days in January, 28 in February, and then our 17 in March, however many that shook up to be. So could you have a credit to the buyer? Sure. If the seller owes them for their portion of the taxes. Let it marinate. Again, we're going to see this again. We're going to work some more scenarios. Just introducing you to it. And remember, you guys, we're recording. So you can always come back through and watch that recording, pick that back up. We're going to talk about prorating HOA dues and rent. I'm going to save that for tomorrow night. So it'd be like a nice refresher for prorating when we come back to it. So we'll see that tomorrow. Another piece of math, clear your mind. Another piece of math that we're getting ready to see on the settlement statement is called interim interest. Interim interest is what the lender charges the borrower to get them caught up on their interest payment. So let's understand a few things first. Interest is charged in arrears. Do you guys see the word rear embedded right there? Everybody look with me. Where's your rear end? Your rear is behind you. So when we say interest is charged in arrear, when you make your mortgage payment on December 1st, you're paying November's interest. When you make your mortgage payment on January 1st, you're paying December's interest. That's what I mean by interest is charged, interest is paid in arrears. Do I have everybody so far? Always look at where your rear end is. I'll let you do that during the test. So that payment you make on the 1st, you're paying last month's interest. The lender wants to collect interest from the day they originate the loan, which is the day of settlement, the day of closing. So the lender is going to come in and charge interim interest to get the borrower caught up. So again, if we have a visual, now I want to go to closing. Let me think. Let's go to closing a couple days ago. Closing happened on November 26th. If we go to closing on November 26th, when will the borrower, well, let me say this. The borrower's first mortgage payment will not be December 1st. The borrower's first mortgage payment will be January 1st. They get to skip the first. When you're originating a new loan, you do not have a mortgage payment on the first. Why? Because interest is charged in arrears. So if you had a mortgage payment on December 1st, you would be paying all of November's interest. Does that seem fair? You didn't own the home the whole time in November. Why are you paying the whole month's interest, right? So you can't have that payment on the first. So we always skip the first. Meaning if we go to closing on the 26th, your first payment is on January 1st. And when you make that payment on January 1st, you're paying December's interest. Interim interest then is the borrower getting caught up on their interest payment, paying the lender what they owe them from the day of closing, the day that the loan is originated, to the last day of that month. Interim interest is always the day of closing to the last day of that month. Let me put this up here so we can see it. Questions so far? It's really important when we're counting days that we count our days right, so we get the accurate amount, the number of days. And when you're counting forward on the timeline, it's really easy to count wrong. So I have a surefire way, a tried true to method to make sure that we calculate the number of days right. Everybody ready? Getting ready to blow your minds. We're going to count it out on our fingers. So I want you to take your hand and say November 26, 27, 28, 29, and 30. Is it really easy to look at that and see 4 days? Guess what? You just got the whole thing wrong because you didn't count your days right. So when you're counting forward, count it out. The borrower owes for the day of closing the 27th, the 28th, the 29th, and the 30th. Count it out when you're counting forward. So the buyer owes their lender for 5 days of interest called interim interest, and that gets them caught up on their interest payment. Doesn't the lender want interest today when they originate the loan? You better believe they do. They can't charge you on the first because that would be for the whole month. So they're going to get you caught up. They're going to charge you for these 5 days or whatever. Interim interest is always the day of closing to the last day of the month. Questions before we look at the next piece? How did I get 5 days? Questions so far?
So are they charging the buyer and the seller for the same day? Or would they?
We're not prorating.
Okay.
This is not a shared expense between the buyer and the seller. This is
Oh.
between the buyer and their lender.
Okay.
So thank you, Selena. Only when we prorate, only when we have that shared expense. Anything to do with the buyer's loan is the buyer's responsibility. So we have our 5 days. The next piece is to figure out how much. So I need to put this somewhere. I'm not giving myself enough room here. I have a formula that we need to jot down. So if you take the balance on the day of closing, the balance is the loan amount. On the day of closing, the balance is what the lender's bringing for the buyer to buy this house. Take the balance times the interest rate, and that gives you annual interest. So the balance or the loan amount times the interest rate gives us annual interest. I need to break that annual interest down to daily. So we divide by 365. And that gives us our daily interest. Now that I know how much interest is each day, now we can say times 5 in this case. And that tells us how much the buyer owes their lender for interim interest. To originate the loan, no payment on December 1st. First payment is January 1st. Pay December's interest. Buyer owes their lender for the remainder of November, the day of closing to the last day of that month. Questions? The next thing I want to do, and I need to stop sharing just for 1 second. We're going to look at a worksheet together. And I want to give you that worksheet. I'm trying to put it in the chat right now if I can figure out how to do it. So then that way you guys can follow along. You can have it. Let's see. I thought that's what it was. Oh, there it is. Pick your chats. Is it there? Should have it. Okay, so you can grab it, download it. We're going to call this your cheat sheet until Saturday the 9th. This is going to kind of be, this helps us. I'll tell you guys, a big tool in doing these closing disclosures is knowing who's responsible for paying what. What is typically a debit to the buyer, what is typically a debit to the seller, typically a credit to the buyer, and typically a credit to the seller. So this is what I just sent you guys through in the chat. So let's break this down. We're first going to talk about things that are typically debits to the seller. I say typically because that's common. Anything's negotiable though. So always do what the problem tells you. Did everybody just hear me? Always do what the problem tells you. If it doesn't specify, this is what's typically going to happen. So let's talk first about the debit, the sellers, and things that they are typically responsible for. The seller is going to have a debit for your commission, our commission. The seller will have a debit for the deed preparation fee. The seller pays the attorney to get their deed ready for settlement. The seller pays excise tax. We'll refresh that in just a second. The seller has to pay off all their existing loans and liens. They have to pay the recording fee to pay off those loans and liens. As we said, the seller is responsible for any delinquent taxes. The seller will more than likely be required to pay any personal property taxes that are due, either delinquent or current. We're going to see the seller's debit list is a lot smaller than the buyer debit list. Buyer generally owes more than the seller when we go to settlement. So I think it's my opinion that if you guys focus more on the seller's debits and know that everything else is typically going to be responsibility of the buyer. I think the things that are easier for us to see are the things that are solely strictly to the seller. So the seller has to pay off their own liens. The seller has to pay delinquent taxes, personal property. To help with the confusion, to help understand commission, deed prep, and excise tax, I always say if you can remember your alphabet, CDE, then we know the seller is going to be paying commission, the deed preparation fee, and the excise tax. And then anything else that's specific to them. Then we look at things that are typically debits to the buyer. Anything to do with their due diligence. Inspections, all those inspections that they chose to get or not to get, those are going to be buyer debits at settlement. Their first year homeowner's insurance premium. We know when you pay insurance, you make your payment today and you're covered for the first year, right? Covered for the next year, right? When a buyer buys a home today, they pay insurance today to cover them for their first year. So they're going to pay that full year's homeowner's insurance, debit the buyer. Anything to do with the buyer's loan origination fee, discount points, interim interest, private mortgage insurance, anything relating, remember the relationship is between the buyer and the lender. So anything relating to that loan will be a debit to the buyer. The buyer pays to have their brand new deed recorded. The buyer also gets to pay to have the lender's deed of trust recorded. So both of those will be debits. And I just want to point this out so we can see the difference. The seller pays to have the deed prepared. The buyer pays to have the deed recorded. When the attorney is getting the deed ready for settlement, it's still the seller's deed. So they get to pay to have it prepared. Whose best interest is it for them to get their brand new deed on record? The buyer. So they get to pay for that. Do we see that difference, that distinction there? Seller pays to have it prepared. Buyer pays to have it recorded. And again, the deed of trust or the mortgage is in the best interest of the lender to get that recorded, but they'll let the buyer pay for it. The buyer will pay for their title and the lender's title insurance policy, the lender's and theirs. When we talk about title insurance, it's an owner's policy. It kicks in when the buyer becomes the owner. That's when title insurance protects them. So whenever that deed gets recorded, the buyer's now the owner and they have their new title insurance policy. So when you see owner's title insurance, we're looking at the buyer, debit to the buyer. There's their survey. If they get one, the buyer hires the attorney. So the buyer gets to pay the closing attorney's fees. Any of those escrow amounts that are going the cushion, they're going to pay for that. And then there's a couple things that are typically POC, which means they're paid before settlement. So we're going to have the appraisal fee. The appraiser's not going to go out and do their thing until they've been paid. We're also going to have the credit report. We'll look in just a second, make sure we put this in the proper place because we want to make sure that we don't charge the buyer for this again. They've already paid it. And remember, you guys, any money that changes hands as a part of this transaction must show up on the closing disclosure. So even though the appraisal's already been paid, it still needs to show up. It'll be a paid outside of closing. Anything here on the buyer's debits? Questions on any?
So if the appraisal's already been paid for, then, well, I guess you're going to get to how it's dealt with on the settlement statement, right?
Sure will. Yep.
Okay.
Then we have some things that are going to be credits to the buyer. The earnest money deposit will be a credit to the buyer. Remember, the earnest money deposit's been hanging out in an escrow account since we went under contract. Buyer's agents, remember when we went under contract and we told the buyer, if we make it to closing, the earnest money will be credited back to you at settlement? Well, now we're making sure that we do that. So we make it to settlement, that earnest money deposit will be a credit to the buyer. Another credit to the buyer is going to be the loan amount. The lender is bringing money on behalf of the buyer today in order for them to purchase this property. The buyer can't purchase it without the lender bringing the money. So the lender sends the money in today on behalf of the buyer so they can use it to buy the house. And then the buyer spends the next 30 years paying them back. So the loan amount on the day of settlement will always be a credit to the buyer, money coming in on their behalf. Here's kind of our prorated cheat sheet. So whether or not taxes have been paid or not paid, credit the seller, debit the buyer, or other way around. So again, we're going to talk about HOA and rent. We'll do that tomorrow night. But this just kind of gives you a handy dandy little place to put this information. And then we have double entry items. Double entry items meaning they're going to show up how many times on the closing disclosure? We're going to see them twice. A double entry item that we will always have is the sales price. Credit the seller, debit the buyer. The buyer is giving the seller the sales price. That's the whole gist of our offer to purchase and contract, isn't it? I promise to give you X amount in exchange for the property. So at settlement, the sales price will show up as a credit to the seller, debit to the buyer. The due diligence fee will be credited back to the buyer. Remember when we went under contract, we paid the seller. The buyer handed the seller a check, didn't they? When we went under contract, that buyer handed seller the check. So that would have been a debit the buyer, credit the seller. Now that we're at settlement, we need to reverse what we did. I know we are not accountants, but how do you cancel out a debit? With a credit. How do you cancel out a credit? With a debit. And that's what we're doing here is canceling out. We're reversing what we did when we went under contract. The sellers received that money once. We can't have them receive it again. The buyers paid it once. We can't have them pay it again. Assumption of the seller's loan. Again, we'll look at that. Talk a little bit more about that tomorrow. And then just a couple other things there. You may negotiate separately sold outside bill of sale personal property. Sometimes buyers walk in the garage and say, does the car come with the house? You know what I always tell them? Anything's negotiable. Money talks. What you want to pay? Let's see if the seller's willing to sell. I don't know. Let's see. So if we work out some kind of separately sold personal property, that would show up buyers paying the seller for the car and the dining room furniture and the, the bookcase, whatever it is that we negotiate. So again, take this, treat this handy dandy little cheat sheet, I should say. You guys can reference this as you're doing. We got plenty of practice for you guys, so you can reference this as you're working through these to help prepare you for that exam. I can't let you use this for the exam. I get asked that all the time. So let's just go ahead and throw that out there. No, I can't let you use this for the exam. I know, right? But we're giving it to you like in advance to help you have you use it as you're working through this and just get familiar with what typically is a debit to the seller, credit to the seller, debit to the buyer, credit to the buyer. Questions on anything on this worksheet? Okay, so let's look now at our blank CD. Again, maybe you were able to print one for class today. We got it up. We're going to look at these. The big thing is I need you guys to bring one of these to test day on the 9th. So I know a few of you had problems downloading from the online learning system. I don't know why either, but if you find that you have a hard time downloading from the online learning system, just shoot me an email. I can respond real quick, send an attachment, and then you'll have it so you can print it for the test. Please, please, please don't wait until Friday night on the 8th and say, Julie, I don't have the CD. Let me help you now where we have time. Is everybody good with that? Okay. So let's talk about what this is, what we're looking at before we actually start using this thing. You can see on the left-hand side, it's broken down into A, B, C, D, etc. I think we go the whole way through like N as in Nancy. So we got the different sections broken down, the different categories. You have commonly used items in this. Tina, can you send me an email just in case I don't see that later? Where's Tina? Thank you. I have a hard time seeing chats sometimes after we go, so thank you. So what we have spelled out for percentage of loan, discount points, loan origination fee, appraisal fee, credit report, the various things that are listed for us here already are the more commonly used things addressed on the CD. You also have spaces here if you need to add, or if the lender needs to add something, some charge that isn't in here. So that's what these blanks are, just for the different situations. The first column or the second column we have here are our borrower paid column. And you can see I have two different categories. We have the borrower paid at closing, and then we have the borrower paid before closing. So let's go back to that appraisal and credit report. Both of those are going to show up. We have to put them on the CD as the buyer paid, but we want to make sure that we get them in the column that indicated that they have already been paid. So how do we not double charge the buyer? Anything that's been paid prior to settlement needs to go in that before closing column. Does everybody see that? The one we're focusing on, the one you guys will need for your exam, is the at closing. So that's the column we really care about. Then we do that same little exercise for the seller. Seller paid at closing, or anything that seller might have already paid prior to closing. Again, any money, all money that changes hands as a part of this transaction has to show up on here somewhere. The last column here is anything paid by others. Remember when mom and dad paid the home inspection? This is where we're going to put it. We're not charging anybody. We're not going to make the buyer pay for it, but we do need to indicate that it has been paid by somebody other than the buyer and the seller. So now that we know our columns, and again, you guys, this is one of these things that if you can spend some time with it and get a feel for what's where, it's going to make the ninth a little quicker for you, maybe even save you some time and get out a little early. So we have A is our origination charges through the lender. You have services, B, that borrower did not shop for, appraisal fee, credit report. C, services that the borrower did shop for. So who's their attorney, deed prep, survey, and again, anything that we need to add in here, we can. If we add up A, B, and C, we get a subtotal of D. And it even gives us the little formula right here. So we're going to tally A, we're going to tally B, and we're going to tally C. And when we add them all up, we get D. We've added up half of the page. Then we go into other costs. So E is in Elizabeth. There's our deed and mortgage recording fees, excise tax. F is in Frank. We're looking at our prepaids. So we're going to look at prepaid interest. Here's our interim interest, for example. Maybe some mortgage insurance premium. If it's a conventional loan, we may have a prepaid there. G is in Jenny, is our initial escrow payment at closing. So that escrow account, that cushion that we talked about that the lender wants to collect, we can initiate the escrow payment, the escrow account. And then H is in Heather is other. Anything else. So there's our commission, the home inspection, home warranty, there's almost always some kind of courier fee or wire transfer fee or, you know, something to kind of nickel and dime them to the very end. So we have a place for that. When we tally up E, F, G, and H, add up E, F, G, and H, and that gives us I. The very last thing on the page 1 is section J, which is D plus I. So we added up the first half, added up the second half, and then in J, we've pretty much added up page 1. For your exam, the closing disclosure, the math piece of it is 4 problems, 4 questions. One question is going to ask you what is the buyer's paid at closing J, and what is the seller's paid at closing J. So we're going to tally up buyers paid at closing, sellers paid at closing. Page 1 on your closing disclosure is all debits to third parties. You will not see a credit on page 1. You will not see an amount between the buyer and the seller on page 1. Everything on page 1 is a debit to a third party. Commission, home inspection, warranty, attorney's fees, lender's fees, pest inspection, survey. This is money owed to the rest of us. Questions on page 1?
I have a question. Is the brokerage fee could be buyer and seller broker fee in each
It
column?
could be, but typically we're going to see it as a debit to the seller. So unless we're told otherwise, Laura, we're going to have it
The seller
down
paid.
here. Yep, seller paid at closing. If it tells you the buyer's paying commission, then we do what the problem tells us.
Okay.
Thank you. You know, like the home warranty, maybe the buyer's paying for it, maybe the seller's paying for it, right? So the problem is going to have to tell us. The problem with something like the home warranty, where there is no who typically pays it, things like that, they'll have to specify. Okay, so page 1, all debits to third parties. Not going to see a credit, nothing between the buyer and the seller. Page 2 is between the buyer and the seller. For testing purposes, this top piece is omitted. This is what we looked at in our closing disclosure, where they did the nice side-by-side comparison for us of the loan estimate and the final. So for your exam, we don't have to worry about this piece of it. On page 2, we're going to do a little bit of origami so we can really see it. So what I want you guys to do first, if you have your paper, I want you to take your paper and fold it long ways. And when you fold it long ways, we are first looking at the left-hand side. The left-hand side is all about the buyers. Buyers on the left, sellers on the right. So things, just looking at the buyers, there's 2 broad categories here, 2 sections. First, we're looking at K, as in Kelly, are all of the buyer's debits. Everything in K is a debit to the buyer. So you can see there, we have the sales price of the property. Closing costs, what we got from J. Remember on page 1, we tallied everything up, debits to third parties. Well, now that we're on page 2, we need to include those for money that the buyer owes. So as soon as you tally up page 1, take that number and put it over at K as in Kelly 3, closing costs paid at closing, and that little J is helping us remember that. If we're gonna debit the buyer taxes, we would do that here. If we have, like, for example, HOA dues that the buyer owes the seller, then that would be a write-in. HOA dues aren't on here, but that would be a write-in. If K is all of the buyer's debits due from the borrower at closing, that means then that L, as in Larry, is all of the buyer's credits. So K is all of the debits, L is all of the credits. And I recommend when you fold your paper longwise, you write a big D at the top and a big C. Make sure you see that K is debits. Can everybody see my paper? And C is credits. And if you put that on your paper early, you can see it when you start filling it in. Once we add up all their debits and add up all their credits, then we tally everything up. And at the end of down here at the bottom is K minus L, everything in K minus everything in L. I forgot to look at L. That tells us what cash, what money the buyer has to bring to settlement. K is almost always bigger than L because the buyer has to bring money. I forgot to talk about L. Let's go back and talk about L. The deposit under L1, this is referring to the earnest money deposit. You guys might want to make a note. This is going to be where we put our earnest money deposit. So the deposit is referring to the earnest money. Credit that back to the buyer. There's our loan amount or amounts. Under other credits, there's our due diligence fee. And then if the seller owes the buyer for taxes or HOA dues, the write-in, then when we have that indicated here. In the real world, they're going to break it down, city, county, school board, fire district, right? Whatever the various taxes are. For our purposes, for your exams, they give you a tax amount. We don't have to deal with the breakdown. So they'll give you a tax amount. We know that's all of the taxes. So K is all of the buyer's debits. L is all of the buyer's credits, K minus L. The third question on your exam is, what is the cash from the borrower at settlement? So the buyer's bottom of page 2. Now we look at the other side. So flip our page over, still folded longwise. Now we're looking at the right-hand side, which is all about the seller. M as in Mary are all of the seller's credits due to the seller. So there's the sales price. And then if we're prorating taxes or HOA dues and the seller is owed, we put those in M as in Mary. N as in Nancy is all of the seller's debits. So again, on my paper, I write a big C on M and a big D on N. You got to start the test with a blank scratch. Blank meaning what you printed out and pulled off the printer, that's what you start the test with. As soon as you see this problem, I suggest right? Your D's and your C's, so we can see what's that debit, what's that credit. For the seller, we tally up all their credits for M, tally up all their debits for N, credits minus debits. Here's your fourth test question on this. Tells us how much, hopefully, the seller's gonna get. Could there be a scenario where N is bigger than M and the seller has to bring money to closing? Yep, sometimes that happens. And guys, honestly, hopefully we knew that back in the day when we were doing the listing agreement. Hopefully this isn't a surprise to anybody today that the seller may have to bring. But typically what we're going to see is the seller getting money. One more origami fold. Open your paper back up. Remember that proration, that debit credit? If the buyer owes the seller, now if we fold our paper non-long-wise, what's the word I want? Like this way?
Hamburger as opposed to hot dog.
I'll take it. So if we fold our paper hamburger, we have the proration of the
Are you a
taxes.
teacher? She must be a teacher.
No, it's just what we've always called it. So
Okay.
as a paralegal. But yeah, no.
So now if we fold it hamburger, on the top are prorations for taxes and that write-in HOA due. We have a debit the buyer, credit the seller.
We're on side 1, right? We switched
on
back
page
to side 1.
We're on page 2.
Still? Okay. Sorry.
So the buyer's K is the debit. The seller's M is the credit. Here's our proration, you guys. Debit the buyer, credit the seller. The bottom half, credit the buyer, debit the seller. If that's the case, there's our proration. Everybody see that? If you can kind of finagle your paper a little bit, and again, I think the D's and the C's help, but when we're prorating, we're hamburger, buyer and seller, we're hot dog. My gosh, you just introduced something new into my post licensing class. Thank you. I give you credit the first time. They say I give you credit the first time, and then after that, I take it and run with it. So
Happy to help wherever I can.
So
questions?
Julie, sorry, when
No.
you're hamburgering and you're looking at basically K and M, that's the proration only, or is the proration also going to be continuing into L and N?
It's going to be one or the other. Taxes, HOA dues, somebody owes somebody. So we're looking at K and M or L and N.
I see. Okay. Okay.
Now,
And then
now
one more.
Nicole, it could be that taxes are a K and M, but HOA dues are an L and N, right? So but that's a different proration.
Okay, yeah, got it. And then just while I have you, for the calculation on these sellers transaction side, you're adding M and N together, right? Not subtracting.
I'm subtracting M from, I'm adding up M, I'm adding up N.
So that's the same,
seller-
okay. And
the
then you're
credit-
subtracting the two.
Yep, credits minus debits tell us how much our seller is going to hopefully get from settlement.
Understood. That was a stupid one.
No, this is good, you guys. This is what I mean. We got to dissect these things. If you guys are going to be responsible for checking the accuracy on some of this stuff, we need to know how these work, right? And look, again, I understand you just met this thing, and guys, I hate to tell you this, but not all attorney CD looks the same. Some look a little different, some are worded different, but the idea, the gist, because I need you guys to look at one of these for your buyer and seller and be able to help them calculate, help them know, check it for accuracy. We're going to talk when we come back for break a little bit more about that checking it for accuracy. But like I said, you guys, I think to get you ready for your exams and especially as you guys are practicing, having this who pays for what worksheet here so you can refer to it. And then also get yourself familiar with this CD, because I'm telling you right now, you're going to spend a lot of time up front looking for where it goes. But once you get familiar with it and you spend some time with it, you know all debits to third parties are on page 1. You may not know exactly where the survey is just yet, but when you spend time with it, you're going to have a better idea. Does that make sense? All debits to third parties are on page 1. Anything between the buyer and the seller is on page 2. So please spend some time with the blank CD, familiarizing yourself with what's where, in addition to the math that we're going to do when we get back from break. What other questions or comments do I have so far?
So at the bottom where it has cash to close on the buyer side.
Uh-huh.
So generally it's going to be from the buyer, right? And
Correct.
generally on the seller side, but like you said, it could be from the seller depending on
It
what the
could.
balance is. Okay.
Yep. So generally we got the buyer owing money, we got the
Mhm.
seller getting money. But you know, every transaction is a little bit different.
Right. So that's why we do the debit minus credits on the left side, because that's what he owes. And on the right
That's
side, we do credits minus debits because that's what they receive.
You got it.
Okay.
So,
Got it.
quick question.
Yeah.
Remember how you said that the buyer liked the car in the garage? Would that be included on this sheet, or would that be a complete separate bill?
They may agree to do an outside bill of sale, Selena, where they
Okay.
deal with it. And actually, you guys know our NCAR forms committee just created a new form for us to use if we're dealing with an outside bill of sale. So
Oh, wow.
thank you, forms committee. They said, well, gosh, these agents are out here creating their own verbiage to make this happen. We can't have this. So as of July 1st, Selena, we have a brand new form that takes care of that personal property, the car and the dining room set. That is, it's money that changes hands, but that's not part of this transaction.
Yeah.
This transaction is the property. Remember, we're real estate agents, not personal property agents.
Mhm.
So that's why if we do an outside bill of sale, it's not necessarily showing up on this. Usually
Okay.
what's happening is the buyer might bring a cashier's check to settlement to pay the seller for that.
Okay.
But
So-
then what's M where it says sale price of any personal property
There you
included?
go. Yeah.
Is that
M.
it?
Yep.
M, the second
Yeah,
line?
there it is. Two
Yeah.
and 3. Yep. So if we do it on the CD, then that's exactly where we would do it. In my experience in the real world, we do it outside with the cashier's check. Am I doing it right? I don't know. I'm not in jail yet, so I guess I'm okay. Let the lender tell you how to handle that, not Julie. Let the lender tell you how to handle that when we're buying the car, right? I mean, personal property, you know, it's not uncommon to see the refrigerator, the washer, dryer, right? But when you start getting into bedroom suite and couch and dining room furniture and the John Deere lawnmower, the lender's going, whoa, 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 what am I financing? What is it I'm giving you money for? Is it the house or the stuff? And that's where we just need to be careful in general with that personal property. Get with the lender.
So question for you.
Yeah.
Going back to the hot dog style summary of transaction on the borrower's side.
Uh-huh.
So say like, so on the, I guess it would be an L. Would it be an L? I can't remember what we said. About how like the parents paid for the home inspection prior to the that's on page 1, isn't it?
It's a debit to a
Yeah.
third party. The home inspector is a third party. So this column right here, this
Yeah.
last column is paid by others, which would be
Right.
mom and dad.
But if you paid it prior, it doesn't need to go on there, correct?
It needs to go under paid before closing.
Paid before closing. Okay.
Any money that changes hands as a part of this transaction must
Okay,
be on the closing disclosure. And that's why they give us the different columns, Missy. That's why we
Okay.
have something that's been paid before or something that's been paid by others.
got it. I just wanted to make sure that I was
Absolutely.
understanding that correctly.
Yep. I had a
Is it-
buyer once, she said, my boyfriend wants to pay the earnest money deposit. Can he do that? I said, sure. We just had to notify the lender that the earnest money deposit came from the boyfriend, so the lender could put it, I don't remember where he put it, but they put it in the appropriate place to show that it wasn't the buyer that paid that, to show that it was somebody else.
And as a hypothetical, like if you forgot to put that on there, and you didn't know until after closing, would you need to go back to the closing attorney and be like, we need to adjust the closing disclosure, or like, what would you do then?
That could be a change post consummation, but hopefully if we're reviewing them beforehand, that's the kind
Yeah.
of thing that we can catch.
But
We'll
like,
catch
if
it
you
before.
don't, are you gonna get in trouble?
If you don't what?
Like, put that you paid the home inspector or the pest inspector or whatever kind of inspector, are you gonna get in trouble if you don't catch that?
They may question you. They may say, did you review it? Did you get the invoice? Should you have known it be there? I can't
Yeah.
tell you what disciplinary action they may take, but it may come back down to your old car duties to review this
Right,
for
the
action.
fiduciary duty, yeah.
So what are they going to do to you if you don't catch something? I don't know. If you say, oh my God, I looked at it and I just missed it. I'd like to think that, because I mean, the commissioners are human too. You know what I'm saying?
Right,
We all
yeah.
make mistakes. But
'Cause that's-
between the lender, the attorney, the agent, I mean, there's so many people looking at it. The
Yeah,
hope is
exactly,
that
yeah,
more-
yeah, because you got the lender, you've also got like the borrower or the buyer, you've got you've got like 50, 11 people looking at it, so you would hope that like, just on the off chance that would, I
if you
always
find
like
it
to be,
afterwards, you report it, because
yeah,
if not, then you could go down for omission. You know what I'm saying?
Yeah.
So anything we find, we got to report. And again, hopefully we're catching it before settlement.
okay,
But if we find it afterwards, then we need to, yeah, we would need to adjust that. And
Got
remember,
it.
anything that happens post consummation, I mean, I don't know how they would address it. I know every once in a while it's found out that somebody overpaid taxes. So you go back and get a check for $32.13 or something, so there are things that happen after settlement if they're caught.
Yeah,
But hopefully
because-
with enough of us checking this, then we'll be good.
yeah, because I know on a previous slide, it said like not doing that could be a willful failure of material fact. And I wanted to make sure that I was understanding that correctly.
Exactly. Yep. Thank you. Selena?
How many days do you have to make a post addendum? Like what's the timeline there? If you she says you just randomly catch, you're like, oh my gosh, I forgot. How much time do they give you to make a post addendum?
I don't know. I don't have an
No.
example of real life, something like that happened after closing. So honestly, if for me, if it was the next day or a week later, and I said, oh my gosh, we forgot, I'd probably go to my BIC first and see how to handle that. But I mean, usually we're not reviewing the CD, you know what I'm saying, after the
Yeah.
fact. Once it's done and we close the file, and I don't know about you guys, but we're done. You know what I'm saying? So could things happen after closing? Sure. How do you handle that? I don't have those answers. So just may have to deal with that on a case by case kind of scenario. Okay. Let's go ahead and take our break. We come back, we're going to talk about the things that we're responsible for accuracy. And then we're going to talk a little bit more about the CD. back. So, let us take our attendance, talk about a few more things on this closing disclosure, and then we can work a practice one together. We'll talk about what tomorrow is going to look like. So, several times we've mentioned I can only verify the things that I can reasonably know. There's no way I can reasonably know all the figures on this closing disclosure. So to talk about that, what I want to do, let's go back to your book. And we looked at that closing disclosure at the end of chapter 14. Doesn't have a page number, but I'm on the page that looks like the CD. So we got the loan estimate. So there's 493, 94, 95, 96, 97. It would be 498 and 499 if we had a page numbers. So what we're looking at on those pages is the sample, the completed closing disclosure, and you can kind of see one in motion. Now, again, in practice, you're going to have buyers on one, sellers on the other. You're going to have them separate. For our purposes, for your exam, we got to lump everybody together because we're not going to use two CDs. But in practice, you're going to have one for the buyers and one for the sellers. So you can see this thing in motion. You have all the borrowers paid. So there's their A, loan origination costs, B, C, E, F, G, and H, etc., tallying all that up to get to J. And then same thing with the sellers, their excise tax, and then their others, the commission, etc. Things that I can verify for accuracy, or actually let me say things that I can't verify for accuracy. I'm not privy to the conversation between the borrower and their lender. So I don't know what the lender quoted the borrower. I should be able to look at that and make sure that it looks normal. Normal is probably going to be like 1, 2, 3% loan origination fee. I don't know for sure, and I can't verify it, but I can make sure I have no little red flags go up. I may or may not know the appraisal fee. I may or may not know some of these things, but again, I can just kind of check them for accuracy. Things that I can know. Let's talk about things during the buyer's due diligence process. We said that a lot of the due diligence providers, the inspectors, the surveyor, those people that help the buyer inspect and investigate the property, a lot of those providers will allow the buyer to pay for their services at settlement. And if they allow the buyer to pay for that service at settlement, they're going to send you the invoice. When they send you the invoice, it's for you to forward to the attorney to add to the closing disclosure. If you ever receive an invoice, can't I now verify that that's accurate on the closing disclosure? If I didn't get an invoice, I can't verify it. But if I received it, any kind of invoice or receipt, I can verify that, right? Other things that I can verify over to our buyers and sellers. Well, can y'all verify your commission? That's math we're going to make sure that we do, right? So if we're going to do our commission math, let's do buyer and seller math with that same kind of eagerness. Y'all verify your commission. Sometimes they get miscalculated. Catch it before closing. Excise tax, like we said, prorating, things like that. Go over to the buyers and the seller side. We can verify the purchase price. We can verify the due diligence amount, the earnest money deposit, seller paid closing costs. When I get this closing disclosure, the first thing I do is pull out the contract and any amendments to the contract, because I can make sure that those numbers that are on the contract are accurate on the closing disclosure. Like I said, we can prorate taxes, HOA dues. We'll be able to do interim interest. So we can't be responsible for the whole thing. But if we have it, if I have knowledge of it, if I've received it in my possession, I can verify it for accuracy. The other thing I can do is just straight line add. I can make sure A plus B plus C equals D. I can make sure that E plus F plus G plus H equals J. I can make sure that all of the buyer's debits minus all of the buyer's credits tell us how much our buyer has to bring to closing. And I can make sure all of the seller's credits minus their debits tells us hopefully how much the seller is going to get. So we're verifying and we're checking what we know, what we should reasonably be able to know. And then we're just going to check it for accuracy. And when you find an error, this is why we check it. We have a duty to call the attorney and say, these taxes look off to me, or my commission's not right. Y'all gonna call if your commission's wrong, right? Faster than anybody can pick up the phone. We have that same duty with the buyer's numbers is right. I was a listing agent one time, which meant I got the seller CD. Now the attorney sending me the seller CD like the day before settlement. Remember, the lender's not involved in the seller CD, but I'm still gonna verify it. And I was reviewing the seller CD once, and they did not have commission on there at all. It wasn't even filled in. The blank was blank. And I called the paralegal. The buyer's agent was Mike. I called the paralegal and I said, Mike and I want to get paid. And she said, and I quote, whoopsie. I can't even imagine what would have happened had I not caught that. She was the sweetest seller. She's the sweetest person I ever met in my entire life. Is that any guarantee that she'd be willing to sit down and send us a check after the fact? My firm would have had to get involved to try to collect our money. The buyer's agent could have come after us. I mean, had I not checked this ahead of time. By the time we got to closing, it was there. Mike was pretty appreciative of me as well. That brings me to a good point. Buyer's agents, you're probably not going to see the seller CD. Thus, you're not going to be able to verify your commission. I recommend either calling the listing agent or calling the paralegal and saying, I just want to make sure my commission is accurate. If you can't see it on the CD, especially something like that, I recommend just making sure that it's correct, that it's accurate. So I think what we have in the book here, whatever the made up page numbers were we just came up with, that may kind of help you see one in motion and how the different sections, the different categories work and how it all tallies up at the end. And again, this is what we're getting ready to complete together. So let me just pause again. Now we've had a minute to think and catch our breaths and see what kind of questions, what kind of comments, anything on our CD before we look at one. And I'm going to stop sharing while you guys are getting your thoughts together.
The double entry, I guess, is a little confusing to me, but maybe it'll sink in. I guess let me just let it marinate for a bit. But if you can give any tips on it by the end of class, that'd be great.
Double entry is just saying that we're going to see it on the settlement statement twice. So for example, the sales price, we're going to see the sales price twice. We're going to see it in K as in Kelly 1 as a debit to the buyer. We're also going to see the sales price in M as in Mary 1 as a credit to the seller.
I guess I'm not understanding like the due diligence, because to me, the due diligence is happening on the buyer's end. So why would that fall under a double entry?
Because the buyer paid the seller that due diligence when we went under contract. The buyer handed the seller a check. So now that we're at closing, we're reversing that. Also, remember when we went under contract, we told our buyer, your earnest money deposit and your due diligence fee will be credited back to you at settlement. So if we make it to closing, those amounts kind of shake out as a deposit, money that they've already put down. So we need to make sure that we credit them. And let me let's consider this. Let's say, I'm going to make numbers up. But let's say we when we went under contract, we had a sales price. We had a sales price of $100,000. We go under contract and the buyer hands the seller an earn it or due diligence fee for $1,000. How much, when it's all said and done, if we don't reverse that, is the seller going to actually collect? They're going to collect the sales price plus that due diligence fee. But that's not what we can, 101,000 is not what we contractually agreed to, right? We contractually agreed to 100,000. So by backing that back out, by reversing what we did, now we have the buyer paying the seller the agreed upon purchase price.
I guess then I was confused with how due diligence is defined here then, because I thought it was basically all the inspections and things like that that take place during that time frame of the inspection period.
That is the due diligence period. And for the due diligence period, the buyer will pay the seller a due diligence fee. And Nicole, with you not being familiar with our contract, that's going to come together when we look at our standard offer to purchase and contract and talk about due diligence and earnest money and how that works. Due diligence is weird to people in other states, you guys. They look at North Carolina and go, do what now? So those coming from other states, we're weird.
Yeah, totally.
Settlement meeting, due diligence fee. We just do things different here.
Totally weird. But hey, question on N as in Nancy, that section, 2 items. The first item, excess deposit, and then item 8, seller credit. What are each of those?
So seller credit could be maybe anything, any additional credit that the seller's given the buyer. Remember, N is all the seller's debits. So if it'd be a seller credit, it would be a seller credit to the buyer. So maybe seller pay closing costs, for example. As far as excess deposit goes, hang on to that, Richard, because we got another problem that we're going to look at that actually addresses both of those fields. It's a little bit more, I'm not going to say complex, but it's kind of like a 201 conversation. And we will talk in a minute. Well, not in a minute, but if you guys haven't figured it out by now, when I say a minute, I mean either in the next few or somewhere between now and the 9th, right? So we'll talk about that. But we do need to address those couple different scenarios, and we'll work on that. Maybe tomorrow, maybe we'll give our brains a little math break tomorrow and then pick this back up maybe first of next week. This is why I rearranged 302 and do chapter 14 before chapter 11. This is it right here. So I want to make sure we have time to talk about these different scenarios, but I want to kind of do it in chunks so as to not overwhelm anyone.
Under the C section, where it says services borrower did shop for, all these things here, aren't they handled by the attorney?
So the closing fee we're paying the attorney for. Remember, the attorney's charging the seller for the deed preparation fee. So C's and Cat 2 is going to be a seller paid at closing, the deed prep fee. Title insurance premium is paid directly to the title through the attorney, but it is paid directly to the title insurance, pest inspection, and survey. So there's services that the borrower did shop for, like the attorney, the survey, the pest inspection, that kind of thing.
But
That
not
deed
the title
preparation.
search, not the title search, not the things that are listed, the title search, the lender, title insurance.
Title search is going to fall under the attorney's closing fee. That's going to be part of what they charge.
Oh, gotcha. Okay, since you shop for the attorney, so those things are just covered. Okay.
That's right. That's right. So what the attorney, once you hire that attorney, you pay them X amount and then they do, yeah, they do their thing. Yep.
Okay.
Okay. So we're going to work through one of these. And again, I got some more scenarios to talk about, but we're going to start with this one. I'm in the online learning system and we're in the unit 4 material. And in the unit 4 material is an in-class CD. So this is the one that we're going to look at together. It does include the solution. So if you want to go back later and look at it, you do have the solutions. While I'm here, and before I forget, also in the online learning system are some extra practice CDs for you guys. There's CD 1, 2, 3, 4, and 5, and then all with the solutions. So we're going to do, I can't make it mandatory, so I'm going to release it. I'm going to call it a highly recommended homework assignment. We will talk about that in a second because I want you guys to have the opportunity to work on one on your own. And then we'll come back together later next week and revisit it. So we'll see that in just a second. But I think if we can do the problem that I'm going to give you, the highly recommended homework assignment, if you can do that one, then you should be set for the 9th. So did that just make that highly recommended homework assignment a little bit more appealing? Again, I can't make it mandatory. I can't make you guys do it, but we're helping you prepare for the test. I like starting with the in-class CD though, because it eases us in and introduces us to a lot of these things and helps get you ready. And again, I'll tell you what that homework assignment is, but you have some other practice, lots of practice here as well with the solutions. So if you haven't signed up, if you haven't gotten yourself signed up in the online learning system, please go ahead and do it because there's some good, valuable stuff in here to help you get ready for that test. So in the in-class CD, I'm going to finagle my screens a little bit so we can see everything. As best as we can with the dual screen. So you guys have a CD in front of you, and then you have my screen. You can see the one, that in-class CD that we're working together. Your test consists of 6 math problems. 4 are straight from the CD, 2 in the bottom of page 1, 2 on the bottom of page 2. Your other 2 math problems are just straight proration problems. So practicing proration is going to get you several questions on that test. And we got some practice again in the online learning system, but just working through, I think, a few of these CDs, things are going to start clicking. I want you guys to save the math for last on your exams or on your exam. So get through the rest of the test first, and then you'll know how much time you have left for the 6 math problems, specifically the closing disclosure. It's going to take you a while. It's going to take you time to go through it. And guys, remember, for 302's exam, you get 3 hours. 301 and 303, you only get 1, but 302, you get 3 because of the closing disclosure, because of this. So you have more time, lots more time than normal. When you guys see this closing disclosure, I need you to read the information first. It's going to tell you what you need to know, such as we're going to use a 365-day year. It may mention that we're going to consider the seller responsible for the day of closing. When you're also doing these, I want you to go in order of the CD. Please don't skip around. If you skip around, you're bound to skip something. So go in order. When you're looking at this problem, go in order from top to bottom without skipping around. Don't go in order of this. Go in order of the problem. So what we're going to do is we're going to go through, we're going to work through this one, and then again, show you where we can get some extra practice and where we have that highly recommended closing disclosure or homework assignment. And then we'll revisit this a little bit more tomorrow, kind of talk about some of these other things that we want to mention. So I have a settlement date on November 23rd. Me personally, I like to write the closing date on the top of both sides, on the top of both pages, because I know the closing date is something that I'm going to have to refer to often, and it may save you some test time if you know it's right there. So you might want to consider, once you write your D's and your C's, you may want to consider jotting down the closing date so you have it readily. So what are the facts of this problem? So I have the sales price. This home went for $249,650,000. Can everybody see my screens okay? See it okay? Okay, good. So we have a sales price of $249,650. What are we going to do with that sales price?
Put it under the borrows column.
We're going to put it on the borrower's column, and
And the seller, they have to get that money as a credit.
that's right. The buyer's paying the seller. That's why it's a double entry. Our 17-page offer to purchase and contract. That's the whole gist of it. I'm going to pay you $249,650 in exchange for your property. That's what it's all about. So the sales price is always going to be a debit to the buyer, which is going to be under K as in Kelly. K1 sales price. And also, oh, just a little bit there. That's good. I can work with that. And also M as in Mary, M1. Debit to the buyer, credit to the seller. The buyer's paying the seller the sales price. So K is in Kelly 1, M is in Mary 1. Then we have our $2,471 real property taxes paid by the seller before closing, and we're instructed to prorate at closing. Well, closing is when? November 23rd. So either the seller's already paid them, or we're going to do a double debit. So the problem tells us the seller's already paid. I see the word prorate, and the first thing I want to do is get my visual, draw out my image so I can see what it is that I'm working with. My annual taxes, and what divides the year is the day of closing. Is everything okay on y'all's end? Did I just say something? I just lost like 2 people as once. I wonder if I didn't have it. Did I say something? Okay, good. I wonder if we just didn't have internet glitches. I'm like, oh Lord, what did I say? Okay. Both of them just went off just like that. All right, so what divides the timeline is the day of settlement. Seller owns the property the front part of the year. The buyer owns the property the latter part of the year. I recommend the visual. At this point is where we need to stop and ask ourselves. The seller's already paid the taxes. The tax bill is for this year has been paid. The seller's paid the whole bill. So you guys tell me who owes who.
Buyer owes the seller.
Say it again, Andrew.
Buyer owes the seller.
The buyer owes the seller for, thank you, for the period of time that they're responsible for. And what's the period of time they're responsible for? When they own the property. Okay, here comes somebody back. Okay. That was weird. 2 of them just dropped off. So we know that the buyer owes the seller, which on the CD is going to shake out as a debit the buyer, credit the seller. That's what we're saying. The buyer owes the seller. Remember that check I handed you? When it left my hand and it entered your hand? That's what we're doing. The buyer is paying the seller for their portion of the taxes. The period of time that the buyer is responsible for is the day after settlement through the end of the year. The seller will pay taxes on November, be responsible for taxes on November 23rd. When we woke up the day of closing, the seller still owned the property. If everything goes according to plan today, when we wake up tomorrow on the 24th, now the buyer owns the property. So the buyer's responsibility is the 24th to the 31st, the end of the year. And remember, when we're counting forward in the timeline, I know there's 31 days in December. We got that. But for the rest of November, I want you guys to count it out on your fingers. So the buyer for November, they owe taxes for the 24th, the 25th, the 26th, the 27th, the 28th, the 29th, and the 30th. We got 7 days left in November, plus 31 days in December, tells us that the buyer owes the seller for 38 days of taxes. Debit the buyer, credit the seller. Questions on how I got that 38?
Julie, I know you said it. I was not paying attention. I apologize. Why are we not using the 23rd as one day?
Because the seller is going to be responsible for that day.
Okay.
When we prorate, the seller is responsible for the day of closing.
Okay, thank you.
So the seller pays taxes today. That deed changes hands at some point today. Tomorrow, we can't call the buyer tomorrow, can we? They are the brand new owners.
I have a quick question. Can you hear me?
Yeah.
Okay, so when you look at the little line thing that you drew, so whoever has more, in this case, the seller has more days, I guess you could say, would they be the ones getting the credit? Could you think of it that way? Or is that not right?
I would be very careful with that train of thought because I can't verify that that would be the every single time. You know what I'm saying? Here it is. And maybe, because it could be that if we're going to closing, let's see, what, 6 months in a year. So if we go to closing in July or August, the seller still owes more, but they haven't paid taxes yet. So in that case right there, that wouldn't work out. So no, I would not rely on that. I wouldn't. I like the who owes who to make sure that we're getting that debit credit piece right. I like your thought. I like
not understanding why, like, who owes who. So is the cutoff September? Once it hits September, then you can see who owes who. I guess that's just what I'm asking because I don't understand.
Okay, so why does the buyer owe the seller? Because the seller has already paid the taxes. So in this case, it doesn't matter September. What matters is that the seller's already paid the whole bill for the whole year. So now the buyer has to, I got to pay you back. I'm going to reimburse you. You've already, the bill for the year is paid. We're done. The seller is going, whoa, whoa, whoa. There's 38 days this year that I didn't own the property. Why should I be on the hook for that? And that's what we're looking for. Have taxes been paid? Have taxes not been paid? If they've not been paid, that's where that September date makes a difference. Not been paid, that's where before September is the proration, after September is the double debit.
But it could also be after September and they still haven't been paid as well.
That's right. That's right. And that's when we would do the double debit. Yep. Yep. Okay. So we got our 38 days. Now we need to figure out how much. The problem tells me that taxes this year are $2,471. We are using an actual calendar year. So if we take our annual taxes and divide it by 365, I get daily taxes of I'm going to round there and say 77. I got 6.769, something. So I'm going to say 6.777 is our daily taxes. times that by 38. And I get an amount of 257.26 that we just decided is going to shake out as a debit to the buyer, credit to the seller. I took my annual taxes that the problem gave me. I divided them by 365 to get daily taxes. Take the daily taxes times the number of days, and that gives us our amount that the buyer owes the seller. Debit the buyer, credit the seller. When we look at our CD, origami, hamburger, buyer's debits are K, seller's credits are M. So that 257.26 is going to go somewhere around 8, 9, and 10. Again, in the real world, they're going to have the breakdown. City, county, school, whatever. For our purposes, just get it in K.
So question, when I did the math, I didn't round off at the 677. I just let the calculator carry however many digits and then multiplied by 38 days.
Yep.
And I got 257.25 on the test. Is that going to matter? Is this multiple choice, or how does it,
It is multiple choice.
Okay.
And rounding alone, you can't miss a problem by rounding alone. So in other words, Richard, they're not going to have two answer choices pennies off. However, they may have an answer choice $6.77 off, banking on you counting your days wrong, right? So that's what, don't get carried away with rounding, y'all. At least go out 2 decimal places. If 3, Richard, you did the safest thing. The fewer times you have to clear your calculator, the better chance, the less chance for human error you have. So the most accurate is not clear your calendar. If you do want to round, I kind of had to round because I'm running out of room. But I typically do what you do here as well and just let the calculator write it out. But again, at least go out 2 decimal places. And if you're a penny or 2 off, your answer choices won't be. So you can look at 255 or 226 and say 25 is close enough. We're mean, but we're not cruel. Taxes. I got them in K as a debit to the buyer. I got them in M as a credit to the seller. The buyer's paying the seller, reimbursing the seller for their portion of the tax. Remember, you guys, the whole idea of this is for them to finalize, for them to settle everything. Is the seller happy now? They collected money for the taxes at the time that they didn't own the property. And that's what we did. We took that shared expense and made it fair. Anything else on these taxes while we're here before I erase all my pink? Can I erase the pink? Is everybody good? Going once, going twice. Speak now. Okay. So the taxes, now we have a due diligence fee of $500. The due diligence fee, because both buyer and seller touch it, it's going to be a double entry. So if we look, go down under L as in Larry, L6, we have a credit to the buyer for $500. N is in Nancy. N7, we have a debit to the seller for $500. Due diligence is under L and N. Credit the buyer, debit the seller. Earnest money deposit of $3,500 is a credit to the buyer. We told them when we went under contract, you got to put up this much for due diligence. You got to put up this much for earnest money. If we make it to closing, both of these will be credited back to you at settlement. So still under L as in Larry, the first line there, you may want to write that in. It says deposit, but that's what we're looking for there for the earnest money deposit, $3,500. Seller's loan payoff, $138,425 is what they owe their lender to pay off their loan, their lien. Seller's loan payoff is going to be a debit to the seller. It's their money that they owe. If we look under N as in Nancy, N4 gives us our pay off a first mortgage, pay off a second mortgage, and 5 if you had a third mortgage, a fourth mortgage. We can add in as many of these as we need to make sure that we get all of the seller's loans paid off. The reason the lenders are on L and N, they're not on page 2 as a third party. They're on L and N because they're bringing money. They have money on behalf. They're not considered a third party in this case. They're considered the behalfing of. So the lenders L and N, the payoff amounts and the loan amounts. And the seller's loan payoff, N is in Nancy 4, debit the seller. How are we doing so far?
I got a question.
Yes.
I know it's a little off topic, but why would someone get a second mortgage on their home?
Pay off medical bills, pay off credit card, pay off student loans. Maybe they want to do some renovations, some remodels, some repairs. So many reasons why you can borrow against your home. Startup business, put my home down as collateral.
Okay, Julie, so you said that you put that under N number 4?
Yes, N is in Nancy 4.
Okay.
That
And
is
anywhere else?
Nope. Just have that debit to the seller for them to pay off so we can release that lien.
I have a question. So the earnest money deposit has already been paid to the seller. Where does that, no?
The earnest money deposit has been hanging out in an escrow account. Seller never touches the earnest money. So that's why we only see it one time. Yep. I heard somebody else.
So what is the excess deposit for from the seller?
We're going to get to that. We'll get to
Okay.
that later. Yep. Yep. Again, don't look for fields on a CD. Look here because this problem relates to this transaction. And this is because they're all different, you guys. So some of them may have some fields filled in that others don't, right? Da, 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 da. So don't try to fill in the CD without looking at the problem. We do, working with the problem here. And yeah, we'll look at some other ones with this excess deposit.
So where did you say the 3,500 goes for the earnest money?
L is in Larry 1.
Just under deposit, okay. I see, this is EMD, okay.
I put that in. I don't know why they didn't, but I put that in. So you may want to make a note that deposit is the earnest money deposit. What else just so far? Seller's loan payoff and up.
Okay, so you said that for number 3, there was a double entry. Um, and where does that go?
We
That's
have
the due diligence, right?
their due diligence,
So that's,
So I got
okay,
L.
L6 and then N7.
Yep. Credit the buyer, debit the seller. Okay. Let's take a break. Let's take 10. We come back. I don't know if we'll get through this tonight or not, but we can always know what we have to look forward to finish up tomorrow. we're back. So. Me, take attendance. Let's get back to our CD again. However far we get tonight is as far as we get, and then we can finish it up tomorrow. Talk about these few other extra things that we need to talk about. And then I'll look at that recommended, highly recommended homework assignment. So, myself back here. All right, we did the seller's loan payoff. Up next, we have $840 for private mortgage insurance premium. You guys may know this better as PMI. PMI is what the lender charges the borrower on a conventional loan when the loan to value ratio is 80% or more. Remember, you guys, the conventional loan, they don't have government backing. The government doesn't offer the lender a safety net in the event of the borrower's default. So if a conventional loan, to help insure the lender, until you get that under 80%, they may charge that private mortgage insurance. That's their safety net if you default or if the borrower defaults. So in this case, we have $840 private mortgage insurance premium. And this is something that's going to be paid to the lender. So we're on page 1. We got to go up just a little bit to page 1. And specifically, we are looking at homeowners insurance. Let's see, this is private mortgage insurance premium. So I'm under F as in Frank. F2. Mortgage insurance premium. And you guys, do you guys see all these little spaces in the on the side here? You know, like in the real world, you're probably going to see, nothing right. You're probably going to see like 12 months here. So we all know how long that is. I'm not worried about these little details here on how many months or any of that stuff. What I'm worried about, what I want to make sure we know is to get the right number in the right column. So if we go back up to page 1, the top here, we can see the borrower paid at closing. And this is the column that we care about. So for your exams. So F is in Frank, 2 is our mortgage insurance premium, which the problem tells us $840. And that's something that the buyer will pay, buyer paid at closing. Then we have a homeowner's insurance premium for $684. The buyer has to pay for their first year of homeowner's insurance at settlement. It's going to cover them for the first year. Where are my homeowners on the call? You guys, when you bought your house, because we don't have anything in escrow yet. We don't have anything. We got to, all homeowners insurance is paid in advance. So when you make that payment today, you're covered for the year, for whatever, November 29th to 2024. So at settlement, we have to collect that first year. The lender has to collect that first year to pay Allstate or Geico, whoever we're going to use for that homeowner's insurance. So the first year's policy, still under F as in Frank, we are prepaying your first year homeowner's insurance premium. The buyer will have a buyer paid at closing for $684. Then I have an $85 deed preparation fee. Remind me what we know about the deed preparation fee. There's an $85 fee to have the deed prepared. Seller.
Seller pays for it.
Did I hear? Seller. Seller pays to have that prepared. So let's go up a little bit more to C as in cat. C2 is our deed preparation. We need to make sure that we get it in the seller paid at closings. Everybody see there? Again, you guys, please understand, in the real world, you're going to have 2 CDs. This is just for our purposes. But in the real world, you'll see the sellers We'll see the buyers. We're just lumping them together right now. So $85 deed preparation fee is a seller paid at closing. Then we have a $500 excise tax. This time the problem gave you the amount. The problem may not always give you the amount. So let's take just a minute and talk about how we got that $500. Excise tax is always a debit to the seller. They tax you when you buy it. They tax you while you own it. And guess what? They're going to get you one more time when you go to sell it. So the excise tax is a debit to the seller. Excise tax is 5/100ths of the purchase price. So what I mean by that is you take the sales price, in this case, $249,650. Excise tax is 5/100ths, which means we need to divide by 500. Step one, take the sales price, divide by 500. This is the trick. This is the key to excise tax. There's never going to be change. Excise tax is always a whole number. So once you take the sales price, divide by 500, you're going to round up, always up, to the nearest whole dollar. So our $499.30, always round up. Again, this is the government we're talking about. If that said $499.01, we still round up to $500. So the sales price divided by 500, and then if we don't have a whole number, round up. Excise tax can be found under E as in Elizabeth. E2 is our excise tax, and we know that we're going to debit the seller.
So are you saying we need to remember the divide by 500, or is it just given to us as 500 there?
Either they will give it to you or they will tell you to charge the seller excise tax. So we need to know how we got to that 500 in this case.
okay.
That's what I was explaining. Yep.
So then, for example, so if the price were 260,000, and then you divide it by 500, it's 520. You would put that as what excise tax is?
Mm-hmm. Yep.
Okay.
So under E as in Elizabeth, E2, we have seller paid at closing, $500. Can I erase the pink? Very good. I have a $400 for a survey. We know unless we're told otherwise, it's going to be a charge to the buyer. So under C is in cat, C5 is our survey. Buyer paid at closing, $400. There's a $450 home warranty. We got to know. The problem's got to tell us who's paying their home warranty. There is no typically pays. So in this case, we see that the home warranty is to be paid by the seller at closing. Home warranties under H is in Heather. H3. Home warranty of $450. Seller paid at closing. Each party has a $30 courier fee. Buyer gets to pay their courier fee, seller gets to pay their courier fee. Today, we may not have a courier fee. We may have a wire transfer fee, but there is usually some kind of fee to get the money from here to here. And that's what we're getting at here. So $30 for the seller, still under H is in Heather. H4 is for the seller. H5 is for the buyer. I have a $650 attorney's fee. Who hires the attorney? I can see your mouths move. Who hires the attorney?
Buyer.
The buyer. So who gets to pay the attorney's fee?
Buyer.
The buyer. Yep. So we're under, back up under C as in cat. C1 is our attorney's fee, $650. I have two title insurance policies, one for the lender for $505.40, another one for the owner for $64.60. This tends to cause confusion. The owner policy that we're referring to here is the new owner. We pay title insurance today. Tomorrow, they're the owner and they're the covered for as long as they own the property. So when you guys see an owner's policy for title insurance, we're talking about the new owner. We're talking about the buyer. C is in cat 3, just lumps it all together. So you can see C3 has lenders and or owners policy. You can either separate those out if you want to, or if you just want to add them up. But the buyer gets to pay for both their brand new policy that's starting as soon as that deed records and the lenders. So we add them up. C is in cat 3. We get $570. We have some recording fees. Again, this problem adds it up for you. It says $82. They give you the breakdown. The deed was $26. The deed of trust was $56. Sometimes they'll give them to you separate. Sometimes they'll add them up. They're all just a little bit different, which is why we like to give you guys plenty of practice to expose you to, some of these different scenarios. Guess what? In the real world, not one of these is going to be the same because every single transaction is different. So understanding, working through these scenarios is a big help. So our recording fees go under E as in Elizabeth. And you could see here, if we really want to break it down, we could put the deed and the mortgage in. What do we say that was? 56. Quite frankly, I don't care about those. What I want to make sure is we get the right amount. E is in Elizabeth 1. Buyer pays at closing.
That's the wrong number.
What is it? What I do? Thank you.
Yeah, it should be 164.
What's that?
Should be 164, right?
I got recording fees of $82.
Oh, I thought you add up recording plus deed plus mortgage, no?
It's the deed plus the deed of trust gave us the 82. They just broke that down for us here.
Oh, gotcha.
$82 total. Of that $82, 26 recorded the deed, 56 recorded the deed of trust.
That does look slightly misleading.
Yeah. Okay.
It's clear, yeah, and again, this is just practice, but yeah, the recording fees and then the colon, that semicolon there shows us that we're breaking it up.
They should have done an arrow instead.
I'll submit that to the.
Because I would have done the exact same thing. I would have thought that it was saying that you add up those two. If if I hadn't noticed the colon as soon as you said it, I would have done the exact same thing.
Like I said, the one on your test, it's clear on your test. I think your practice questions are going to be clearer as well. And hey, if you get to the end of this thing and you're $82 off, that might be kind of easy to find, right? So sometimes you can kind of play with those numbers and work backwards if you need to. All right, I got brokerage commission, 6% of sales price to be divided equally between the firms. Brokerage commission is under H as in Heather. In the real world, you're going to see X amount, 3% paid to firm ABC, 3% paid to firm XYZ. So in the real world, you're going to see this split up. For our purposes, if you want to split it up, great. If you want to put in the lump sum commission, that's fine with me too. Just get the right amount in. In the real world, though, you need to verify that your firm is getting what they expect to collect, what we agree to in our agency agreements. And it'll tell you, Julie's real estate shop is collecting X amount. You know, Selena's real estate shop is collecting X amount. It'll break down. I just looked up and saw you. It'll break down the different firms for us. Sales percent is always based off of the sales price. I'm sorry. Commission is always based off of the sales price. So if we go back up a little bit, we're reminded our sales price is $249,650. We are charging 6%. So our brokerage commission total 6% is $14,979. Again, if you want to divide by 2 and put 2 entries there, 7,000 something and 7,000 something, showing that each firm is getting a split, that's fine.
7,488.
There you go. Thank you.
Yeah, but that's paid by the seller, right?
Yeah, that should be in the seller column, right?
Yes, yes. Thank you. Then we have financing. I got a loan, a conventional loan of $212,000. Today, the day of settlement, the loan amount is going to be a credit to the buyer because back on page 2, under L, it says paid already on or behalf of the borrower. The lender has to bring that loan amount on the borrower's behalf in order for them to close. The buyer will spend the next 30 years, for example, paying the lender back. Today, the loan amount is a credit to the buyer. That's money coming in on their behalf. So L is in Larry. 2 is our loan amount. So we had a $212,000 loan amount. 30-year loan with a fixed interest rate of 6.5%. We'll come back to that in just a second. Yep, we'll do that right now. Calculate interim mortgage interest. So we know our loan amount, we know our interest rate. So let's talk interim interest for this buyer. If we're going to closing on November 23rd, when is the buyer's first mortgage payment going to be?
January 1st?
Happy New Year. Start the year off with a brand new mortgage, right? When is interest paid? How is interest paid?
Arrears.
In arrears. Turn around, look at your butt. Interest is paid in arrears.
Up the rear.
And when you make that payment on January 1st, you're paying December's interest. Everybody good so far? Put yourself in the lender's shoes. I know I'm going to get my interest for December when you make that January payment. The lender at some point is scratching their head going, wait a minute, what about the interest that you owe me for the day of closing to the last day of that month? And that's all interim interest is. It's the borrower getting caught up on their interest payment. It's the borrower getting caught up to date with what they owe the lender. Interim interest is always, it's a pretty strong word there, isn't it? Interim interest is always the day of closing to the last day of that month. So now we count. I got the 23rd, the 24th, the 25th, the 26th, the 27th, the 28th, the 29th, and the 30th. There are 8 days that the lender owes, I'm sorry, that the borrower owes their lender.
But I thought the seller owned the property on the day of closing. So why is the buyer paying interest on that?
When we prorate between the buyer and the seller, this is an expense between the buyer and their lender. The seller has nothing to do with this. This is not a shared expense.
No.
This is
That's
all
good.
on the buyer. It's their interest. Only when we prorate.
Yeah, so taxes would be like day after, but interim interest is day of until the end of the month.
Yep.
So it's always one day more than you think it's going to be.
So you can look at that and say 7 plus 1, or you can count it out. Whichever one you see. Whichever one you see. Questions on the 8 days? Now we need to figure out how much. So our formula that we need to know, we're going to take our balance, which on the day of settlement is the loan amount. The balance is the loan amount times the interest rate, which I got to go back, look at the problem. My interest rate was 6.5%, right? Interest rate, 6.5%. So you take the balance times the interest rate. And you get annual interest. I need to break that down to daily. So I got daily interest. I took my balance or the loan amount times the interest rate to get annual interest. Divide by 365 to get daily. Now that we have daily, we can take that amount times 8. And I get $302 that the buyer owes their lender to get them caught up on their interest payment. They are now caught up on interest. They've paid through November. December's interest, they'll collect that when you make January's payment. Questions on this so far before we look at where to put it on the CD?
And they will give you the 6.5%, right?
Absolutely. Yep.
Okay.
So what did you do with the 37, basically the daily interest. What did you do with that afterwards?
Times it by 8.
Okay.
Times it by
By
the
the
number of
days.
days. Yep.
Okay.
So I know interest every single day this year is $37.75. The lender just wants to collect 8 days of that. So we have interim interest, $302. Back up on page 1. F is in Frank. Y'all please make a note of this. I tell you, if I get a question from you guys about the CD, it's not how to do it. It's where does interim interest go? So I don't know why they don't call it interim interest, but if we look under F is in Frank, F3 says prepaid interest. And that's where we're going to put our interim interest. So $302. I guess they are prepaying interest from today till the end of the month. So I get that logic. They just don't call it interim interest. So F3 is our interim interest.
I'm sorry, I wasn't paying attention. I missed that part. Prepaid interest is the interim interest, correct?
Correct.
Okay.
Can I erase the pink? Okay, then we got some loan fees, some lender fees. So I got 0.75% origination fee. I got $280 application fee, and we have one loan discount point to be paid by the borrower. So if we come back up under A is in Apple. You can see you got your points, known as your discount points, your loan origination fee, and then we need to do a write-in for the application fee. So we're just going to plug that in there anywhere.
Are we gonna have
No.
to calculate the discount points?
Mhm.
Okay, that's cool. Yay.
So we have our $280 application fee. All lender charges are based off of the loan amount. What does the lender care about?
The money,
Whose money?
the borrowers,
Their money.
their
It's not our
money.
sales price. The lender's the one bringing that $212,000. Whose money is that? That's the
Theirs.
lender's money.
Yeah.
All lender charges are calculated off of the loan amount. So I have, first off, a loan origination fee of 0.75%. I know my loan amount. We're going to do an origination fee of 0.75%. So for our loan origination fee, we got a charge for $1,590. Still under A is in Apple. A2 is our loan origination fee. And then we also have one discount point. The number of discount points shakes out to the percentage of the loan amount. So if it's one discount point, we're going to charge the borrower 1%. If it is 2 discount points, we're going to charge them 2%. If it's 5.5 discount points, we're going to charge them 5.5%. The loan discount points shake out to the percentage of the loan. So for our discount points, 1%, we're looking at $2,120, still under A. We have our discount point, 0.75 loan origination fee, and then our application fee, all under A, loan origination charges.
I'm willing to bet there will be an option on there that is gonna make you think. So what I did first was I only did it times 0.75. I didn't do the 0.75%. And so I got 159, and then 1,000, I guess, instead of 1,590. So it'll
You missed that
probably
point.
have that, it'll probably have that as an option, like if it asks something like that, because I remember during pre-licensing, it would do stuff like that. Like if
So
you were trying to
remember, I
pay
mean,
for something-
you're not gonna have a question that says how much is the loan origination fee?
Right.
It's gonna
Okay.
be a culmination all at the end here. So, but yeah, I mean, if you
Got
don't calculate that 0.75%,
Yeah.
right? Then it's gonna mess up your numbers, on the CD. So yeah, just make sure you see this, make sure you put it in a calculator exactly how it looks
Yeah.
on the screen.
Yeah. But I know they like to trick you on stuff like that. So it could potentially be an option because they would know that you did something wrong. At least in pre-licensing, it was like that.
Just be very careful with your calculation.
Yeah.
Was it Addie? Was that Addie? It had
No,
the
Missy.
big no. Addie yesterday showed us her big
Oh.
calculator with the big buttons on it, so you can't like mishit something. I like Addie's calculator. It gives you less room for error there, right?
Yeah, I have one like yours that I got at Walgreens. So
Just make sure. Yep, 0.75%. Questions on the discount points, loan origination fee? Questions on anything so far? I know we're about wrapping up for the night. I don't want to get into this next discussion about the escrows because we don't have time to do it tonight. So we'll finish this up tomorrow when we first come together, and we'll start right here and wrap this thing up. And then, like I said, we got a few other things to talk about. I want to look at prorating rent. I want to look at prorating HOA dues, that kind of thing. So, a little bit more on this tomorrow. And then we're also going to talk about that highly recommended homework assignment because there's a few things in that we need to talk about to make sure you know how to do it. Like I said, that highly recommended homework assignment is highly recommended for a reason. And I always say, if you can do that one, you're good for the test. So we definitely want to talk about those specifics in that as well. And then you guys have a little over a week before your exam to kind of master, get through these CDs to get ready. So that's where we are. So we'll finish this up tomorrow, finish up 14 tomorrow. We'll probably get started back in chapter 11 tomorrow night, you guys, as well. So maybe a few more hours with math. And then we're going to get going. The star of chapter 11 is the offer to purchase and contract. So that's where we're spending most of the next couple classes, is going to be looking at that thing in detail. And that's going to help us better remember what happens to the earnest money, what happens to the due diligence, that kind of thing. I do know it can be a little, because I do skip around. So we haven't talked about those things yet. But again, I'd rather give you guys the time to practice the math. If we went order, we would be doing this closing disclosure next Thursday for you to take a test on it on Saturday. So are we glad we're here doing it today? Give you some time to let it marinate and think. Cool. You guys let me know. I'm around all day tomorrow. So let me know if there's any questions, anything I can help with. Again, I know a couple of you are having problems printing. The blank CD. So I don't know why it's on my list, to figure out what's going on with that. But in the meantime, if you need a document from the online learning system that you can't access, you can't get, just shoot me an email and I'll get it to you. I don't know if I don't know. So just shoot me an email and I'll be happy to send it to you.
Julie, out of curiosity, how many questions on this test?
40.
Okay, thanks.
You got to
The
get 30
highly
right.
recommended.
Huh?
The highly recommended homework was all the stuff on all the problems, right?
No,
Or
no,
which
just
ones?
we're
I
going
can't
to talk
remember.
about that tomorrow. We're going to talk about that
Oh,
tomorrow.
okay. Okay. I thought that was for today. Okay.
Yep, we'll talk about that tomorrow. We got to finish this one first, one thing at a time, you guys. Y'all ready? Go on to the next one. I hear you. Let's finish this one first. Fair? Okay. All right.
So
Yeah.
75%, right?
Yes,
So we can miss 10 questions and still
correct.
pass.
Correct. And you have 6 math.
In case anyone was wondering, I just calculated.
I understand getting through the test, but
Yeah.
do we understand the importance of this closing disclosure for the real world? Understanding and knowing that we can verify. I get it. We just want to get through the test right now. I totally understand. But there's a reason why we're going through this exercise, because we got to make sure we're not filling these things in. That's the paralegal and the attorney's job. But it's our job to come behind them and make sure those numbers are right. And that's why we need to make sure that we get through this. It's what we owe our clients, you guys.
Right. Well, I'm highly invested because, I have that closing coming up. So I'm just like,
That's
okay.
right. That's right. And look, the first couple closings you have, go to your BIC, go to your peers, let them help until you can start kind of navigating your way around through this. So that's where we are. Everybody have a good night. Go sell a house tomorrow. We'll see you back on at 5:15.
Good night. Thank you.
Good night. Thank you.
Thank you.
So Julie,